Good afternoon, and welcome to the Appellate Division, First Department. Before I go any further, I want to recognize two future lawyers, maybe even future judges. Today is the last day for Ryan Scott and Vanessa Galvez. They both attend the John Jay Rising Scholars of Justice program. Ryan is a sophomore and served as an intern for Justice Bahati Pittsburgh. And Vanessa is a senior and served as an intern for Justice Ellen Gesmer. And both of them shared with us that these two individuals, Ryan and Vanessa, did an outstanding job. So why don't we give a round of applause for them? And we thank you for your service. So attorneys, listen, obviously we're all mentors and we have to set an example. So we're gonna be on our best behavior and you're gonna do the same thing for Ryan and Vanessa. Now, let me say that today we have over 7.5 hours of argument time requested. So as I call the calendar today, please request the time, not that you want, but the time that you need to make your most salient arguments, because you already know this is a hot bench, we're prepared, we've read your briefs, we're familiar with the issues. So for those that are here with us for the first time, the white light on the lectern will go off when you have 2 minutes left. Or if you've requested less than 2 minutes, it will go on immediately. So when the light turns red, that means your time is up. Not for us, but for you. Now, if the panel has further questions past the allotted time, we will keep asking questions and you will have an opportunity to respond. So when I call your case, please rise and tell us who you represent and how much time you are requesting. And I'm going to apologize in advance. In the event I mispronounce any name, please correct me so that I can pronounce it correctly. With that said, People v. Charlie Casillas. Submitted. Panda v. Gilnet Inc. Mm-hmm. Uh-huh. All right. What we're going to do is 5-2-4-4. Okay. Give me a second. Thank you. Mara v. Raul G. Submitted. Ralph Nolan v. State of New York. Uh-huh. Well, there's no one here, so would you like to submit? Okay. All right. Give you 3 minutes. 3. People v. Jose Montserrat. Submitted. People v. Ha Jay-Z. Submitted. James Russell v. Lenox Hill Hospital. Uh-huh. Okay. right, I'm going to give you what you asked for. 5234. Uh-huh. People v. Everett Gosney. Submitted. Corpin LLC versus One Pin Plaza LLC.
Good afternoon, Your Honor. For One Penn Plaza defendant, appellant, we'd ask for 7 minutes and 3 minutes.
Mm-hmm.
Plaintiff respond in 10 minutes.
Mm-hmm. 525, thank you. Alpha Sense Inc., v. Financial Technology Partners LP. Uh-huh. All right. 524, thank you. People v. Jose Perez. 5N, thank you. All right. 525, thank you. Wells Fargo v. UBS AG. Good afternoon. Uh-huh. All right. 525, thank you. Colop v. City of New York. Mm-hmm. All right. 514, thank you. Matter of Manhattan Organization LLC, City of New York.
Good afternoon, Your Honor. Appellant, Manhattan Organization, 5 and 2, please.
All right. 525, and I realize that I skipped over People v. J. Smith. Thank you. All right, that case is submitted. Valentina you'll help me. Uh-huh. Thank you. Good afternoon. Uh-huh. All right. 525, thank you. People v. Wait, excuse me, Collazo v. Calvert Lancaster Housing. Uh-huh. All right. 4-4, thank you. People v. Barada. Submitted. Bowman versus Cosby. Mm-hmm. All right. 525, thank you. Okay, first case. Panda.
Sorry, I was just opening my computer. Good afternoon, Your Honors. May it please the Court, my name is Jennifer Adler, and I'm appearing on behalf of Guildnet and Lighthouse Guild International. There is nothing in the contract between Guildnet and Ellison that either contemplated or obligated Guildnet to exercise any direct supervision or control over Ellison's aides or Ellison itself. And there is no evidence that Guildnet exercised any supervision and control over the aides. Guildnet was a coordinator, it was a facilitator. The contract was designed with that in mind.
Counsel, the contract references a provider manual. Was that provider manual produced?
It was not produced by either side, no, it was not. But
How does that affect your argument? Would we need to review the provider manual in order to reach the position that you're asking of us?
well, I don't believe so, Your Honor, because what the evidence shows is that there was absolutely no supervision or control over Ellison and its aides. Now, I'll give you an example, actually, from the testimony. So there was testimony that Mr. Pander was unhappy with one of the aides because they were unable, they asked for assistance from a neighbor with respect to using the Hoyer lift, because sometimes a Hoyer lift can require two people to use. So Mr. Pander called Guildnet. Guildnet reached out to Ellison, because Ellison was the agency responsible for supervising and controlling its aides. Paulette Bailey from Ellison went out to the house. She assessed the situation. She made sure that that aide was able to handle the Hoyer lift. And in fact, she came back the next day to make sure that that aide was able to use the Hoyer lift. It wasn't
Also, were Ellison employees required to undergo training that was provided by Gilnet?
The testimony reflects the opposite. It was it does say in the contract that upon time to time, Ellison, as the corporate provider, not Ellison's aides, were responsible for following the contract. But all the evidence, including Shirley Ellison's testimony, was very, very specific, that it was her company that was responsible for making sure her aides were qualified, they were trained, they had their proper certification. There was no obligation on Guildnet.
Was the Guildnet have a standard for Ellison to follow?
Of course, I mean, that is the contract, you know, their standards were part of following the law, the public health law. I mean, it talks about, you know, the rules that had to be followed as a corporate provider, as an agency that it hired. But all of the testimony reflects that Guildnet was merely an administrator of a plan. It was a facility.
Counsel, let me ask you this question.
Sure.
You know, was there any evidence that Gilnet prepared any type of, you know, plan of care for the decedent, or, you know, was responsible for any instructions regarding her care?
There was, so what happens is when Guildnet takes on a member, okay, when a member is assigned to Guildnet as an administrator, they send out a nurse and they talk to the member's physician. And along with the member's physician and their nurse's assessment, they determine if what the physician is saying, for example, the decedent here required 24-hour care, if that is correct. Okay, and then they formulate an assessment, and every month they go, or every couple of months, they go out and they reassess. And particularly they did it here because there was an issue with her going into the hospital, and they reassess, not with the aides. They don't do anything with the aides. The assessment has nothing to do with the aides. All the assessment has to do with is the member. They go out, they make sure the members, what is on that original assessment is still needed. If anything further is needed, then they go to the agencies that they contract with. And it is the agency's responsibility to provide the aides and provide the care and to supervise and control those aides. I mean, there's testimony from Guildnet and there's equal testimony from Ellison that Guildnet was not responsible for supervising these aides. Portia McCormack, the Assistant Vice President for Clinical Support Services from Guildnet, testified it was not Guildnet's responsibility to review the PCAs that Ellison used or any other providers used. And they would have relied on Ellison's determination that the people that they hired, because Ellison, Shirley Ellison and Paulette Bailey were very equivocal that it was their responsibility to make sure that their aides were qualified and trained.
Thank you. You'll have time on rebuttal. Thank you.
Thank you.
Good afternoon, may it please the court. My name is Neil Finkston. I'm here on behalf of the plaintiff respondent. The trial court correctly concluded that there are factual questions as to Guildnet's control over the means and methods of Ellison employees.
How? How is that? What evidence was there that there was any direct supervision or control as opposed to anything incidental?
Well, the provider agreement lists all the specifics as to the nature of the control that GuildNet was to have. GuildNet,
But yes, what they have, but in this particular instance, how?
the GuildNet care plan that was formulated for Ms. Pander after a hospitalization is hanging on the refrigerator and is shown to Ms. Shaw, the aide, at the time she shows up to the house. This is the plan she's required to follow in accordance with the provider agreement. It lists, among other things, that Ms. Pander's in need of a Hoyer lift. Ms. Shaw was shown the plan, as I indicated, by the prior aide who she was taking over for, and Ms. Shaw showed this care plan to the police after the incident. She knew that this was what she was supposed to follow in the course of taking care of Ms. Pander. In addition to the agreement and other records indicating that GuildNet was involved in monitoring the patient's clinical status. This is all on page 3045. There's a nice little note that indicates all the ways in which GuildNet's
Isn't
involved.
that what they're supposed to do as a long-term healthcare plan? They had no, as far as I understand it, they had no involvement in selecting the actual aides that were going to execute this plan.
Well, in this particular case, their involvement, again, was characterized as being more of a coordinator and administrator, and the evidence shows that's far from the case. GuildNet's directly involved in the patient care. With respect to the Hoyer lift, GuildNet knows that prior aides that Ellison has been assigned, and Ellison is actually the second agency that needed to be assigned, that the aides that had been assigned were not capable and competent with respect to a Hoyer lift, and they are involved.
So
Did you,
do the aides report to GuildNet, or do they report to
They
Ellison?
report to Ellison, but as per the provider agreement, and the agreement's very specific, the provider and the provider's employees are to follow GuildNet's protocols, rules, policies that's set forth in the provider manual, but the provider manual also,
did you request the provider manual?
the record doesn't indicate what was available or what was requested, Your Honor.
But did you request it?
I'm appellate counsel. I did not. I
Well,
don't see
understand, but
that in the
I'm
record.
sure you're familiar with the record. Do you know, is
I
there,
don't see it in the
there's no
record.
record of a request for it?
Correct.
So do we know what the manual provides?
No, and that's part of the mystery here and why it's our position that GuildNet hasn't satisfied its burden of proof, that there are questions of fact as to the degree of control, because that manual ties into the agreement, and the provider, as well as the provider's employees, must adhere to the policies within the manual.
If my understanding of this accident, that led to the ultimate death, is that the aide was asleep when the individual fell out of the bed?
It's entirely unclear, Your Honor, because as Ms. Shaw conceded during her deposition, she doesn't really know what happened that night, and she's not really sure how Ms. Pander ended up on the floor.
My question, I guess, it's not during the use or the improper use or of the Hoyer lift.
Oh, no, there are questions of fact about that as well, Your Honor, because the EMT who arrived the following morning observed that the Hoyer lift was broken around the house, and that Ms. Pander was found on the floor with her head by the foot of the bed. There's conflicting indications that the Hoyer lift was used that night. And again, it's our position that all of this testimony combined, I say I'm out of time, if I could just answer your question.
You can.
All that testimony and evidence combined raises questions of fact as to the use of the Hoyer lift, compliance with whatever protocols GuildNet had in place, and ultimately GuildNet's control over the Ellison employee. If there are no other questions, we'll rely on our
Thank you.
brief. Thank you, Your Honor.
Good afternoon, Your Honors. My name is Vincent Maynor. I'm here for defendant respondent Ellison Home Healthcare. I'm here solely regarding the contractual indemnity claim as against my client.
Right, your position is that GuildNet might not be free from any negligence, right?
That's correct, Your Honor.
So in the record, what establishes that if any direct negligence, not incidental, which I think we've all, alluded to up here?
I understand, Your Honor. And so there are both claims in the bill of particulars as well as plaintiff's complaint regarding those allegations. It's on record page 911 and 70, I believe, Your Honor. And in those, there are claims specifically, there's a number of them, but specifically that there was a failure to provide adequate, proper, timely home care, and also quality assurance. You know, that goes through numbers 1 through 5 within the bill of particulars. So those are the allegations made directly against GuildNet in this matter. For those reasons, because of those existing claims, we're arguing that the contractual indemnity should not apply as against Ellison. The PPO, the participating private provider agreement contemplates that if there is any negligence by either party, that party is not entitled to indemnity. As again, I've stated that there is those claims made against GuildNet, and these claims all occurred separate and distinct from the harm that was alleged against Ellison in this matter. I think it's important to note that there's claims that exist prior to Ellison's involvement. So Ellison was brought in June 16 of 2016, and there are claims that originate from plaintiff against GuildNet between the period of March and June 16 of 2016. For those reasons, there's no meaningful allegation that GuildNet caused such harm. GuildNet argues that there is no meaningful allegation that GuildNet caused such harm. But the fact remains that these allegations are set forth against GuildNet, and Ellison could not be made to indemnify for them. The PPA is clear, and unless the court has any other questions, I'll rely on the papers.
Any questions? Thank you.
Thank you, Your Honors.
Give me a moment. Let me just reset the clock. Thank you. You may begin. Thank you.
I mean, it's telling that plaintiff really can't point to any evidence to demonstrate any supervision and control by GuildNet. He keeps citing to general contractual provisions, but yet the contract says the parties acknowledge and agree
They're also
that,
citing to that manual. Is it fatal that you didn't present that manual?
and they didn't ask for it either. But there's nothing, there's nothing in what we have in this record that
Yeah,
establishes.
but what's in that manual?
It is I understand what you're saying, Your Honor, but the facts and the circumstances surrounding this incident, surrounding the care provided by Ellison, and even the care provided by any prior healthcare agencies demonstrates that GuildNet was
Should we
simply,
consider that it was GuildNet that came up with the plan, that it was GuildNet, that it's their plan that was up on the refrigerator?
it was,
that
it
it's their plan
absolutely,
that Ellison- Hold on.
I'm
It's
sorry.
their plan that Ellison staff was following.
Yes, that is their role as an administrator. As I said before, they work with the physician. That's how it comes to them. They're a Medicaid administrator.
Doesn't that tantamount to an instruction?
It's not. I mean, it's not
Why
an
not?
instruction because when it comes to respondent superior and when it comes to vicarious liability, there has to be an employer-employee relationship, and there has to be some control. All of the items that the plaintiff has pointed to, the Supreme Court, all are indicative of incidental control. And incidental control does not rise to the level of direct control necessary to establish that relationship under the doctrine of respondent superior. As for the indemnity agreement, which I did not get to touch on in my initial argument, we submit that any allegations of negligence here are based on any claims against Ellison and Ellison's aid and have nothing at all to do. There's no independent basis. And for the idea that they keep saying that the aides were not trained in the Hoyer lift, there's evidence in the record that dispels that, including Mr. Pander's testimony, where he indicates that he made sure that he watched Shaw and Miller use the Hoyer lift when Shaw first got there, because, as he quote, he didn't want any issues with the aide handling the Hoyer lift. And that
Counsel,
is-
thank you.
Thank you so much.
Thank you. Nolan versus State of New York.
Good afternoon, may it please the court. I'm Annette Hassapidis, appearing for the plaintiff in this case. I've been given 3 minutes, so I'd like to just briefly address the 3 points that are raised by the brief. This is a an unjust conviction case. My client spent 6 years in jail. His conviction was vacated after the Second Circuit determined that but for the deficiencies of his trial, quote, a reasonable jury would likely have rendered an acquittal, assuming that the judge would have even let the case go to the jury because of the fabricated identifications and the misconduct of the NYPD
Was there an
detective.
acquittal? You mentioned the word acquittal.
I'm sorry?
Was there an actual acquittal?
It was a NOLO plea, which under the Court of Appeals Authority in Smith versus Hunter is the equivalent of it. One of our points here, and you know the court is well familiar with the briefs, is that not only is this, according to the Court of Appeals, a final favorable termination of the prosecution, but to conclude otherwise would be to allow the prosecution to defeat an unjust conviction claim by simply filing a NOLA claim. And so one of our viewpoints here is not just that the law under the Court of Appeals Authority recognizes this as a proper dismissal, but that to conclude otherwise would allow the prosecution to self-defeat. I would also refer the court to the case of Owens versus State, which is a recent Fourth Department case where the Fourth Department said that an unopposed motion to dismiss at the close of a retrial satisfied the acquittal requirement of the statute because it's necessary to effect the broad remedial purpose of the statute and allowing the prosecution essentially to force the plaintiff to go through the motions and then decline to oppose the trial order or dismissal would defeat the purpose.
What is the basis for your claim that the Court of Claims has jurisdiction over this claim that arises out of a federal prosecution, not a state prosecution?
It is under the statute does not distinguish between New York State or state. It is referring to the geographic territory.
It says the state.
It says, right, the state lowercase. In the same statute, it refers to New York State. It also refers to the United States Constitution. And there's no basis for concluding that a federal prosecution is not covered here. The legislative history and the bill jacket do not limit the ability of an individual to seek compensation
Why would New York State grant permission to be sued for actions of the federal government?
Well, because in this case, the NYPD engaged in the misconduct, engineered a false prosecution, then knowing this, passed it off to the federal authorities.
But that's the particulars of this case. And,
That's correct.
What I'm asking is directly to the authorizing statute, right? When they use the word state, why would we interpret that to include actions, federal prosecutions?
Because the word state it doesn't refer to state prosecutions. It says within the state, and it's in its lowercase, and the statute separately in other places refers to New York State. When New York State, the governing authority,
And we're talking about the Court of Claims Act, right?
yes, we are.
Okay, so for
Right.
New York State.
Right, well, this is a compensation scheme that is administered by New York State for individuals who are unjustly convicted in New York State. The statute, it's unfair when we
Why
consider-
wouldn't we then, never mind.
Well, I want to go back to the Constitution because you did mention that.
Yes.
And, I'm just curious because certainly, as you indicated in your brief, there are certain sections that refer to the Constitution.
Yes.
But certainly, the statute that we have here doesn't refer to the Constitution. And, we all know about the rule that if the legislature intended to use a particular phrase or word, they would have. And so I'm just curious, how does that help you when the sections that you cite in your brief really focus on relief, as it relates to statutes that are constitutionally infirm, would give a claimant relief? So certainly you're not saying that this statute is constitutionally infirm.
I'm not saying the statute is constitutionally infirm. I'm
Yeah.
saying that the lower court's interpretation of it, the narrow, myopic interpretation of it is, the statute itself does indicate that
The statute itself reads, has been convicted of one or more felonies or misdemeanors against the state. That's what it says.
Your Honor, where are you? I'm trying to look at where you were reading.
I mean, I could be reading directly from your brief, because if you're going to cite the statute, that's what it says. However, I'm reading from the Court of Claims Act, Section 8B, subsection 3A,
Oh,
okay?
yes, we are moving for seeking relief under 3B2.
Yes, and 3B2 also says that convicted and subsequently imprisoned. It again says against the state, and it talks about these convictions. And I just don't understand what line of reasoning would New York State, what interest would New York State have in, if someone is convicted on a federal level, that New York State, and then it's overturned if there's an acquittal, that New York State would then compensate someone for that. What interest would we have in doing that? Maybe there's a federal equivalent to that, where the federal government would have an interest in compensating people who have been wrongfully convicted. But what interest does New York State have? And I just don't know why we would, from your case, and then implement that for cases coming forward.
Well, we have, this was a federal prosecution in the state of New York. He was convicted by a jury impaneled in New York. He served his time in a prison in New York. Right.
Was it in
And-
any of the state courts?
I'm sorry?
Was it in any of the state courts? I thought this took
No,
place in a
no,
federal district court.
No, they passed the tainted prosecution off. It was, the fraud and the misconduct started with the NYPD.
And where
then
did the
it was passed
conviction
and-
occur?
In a federal court in New York. I would
So
point
it
out.
didn't occur against the state. The conviction was not within it was
Right.
geographically, yes, within the state, but not in a state court.
Yes, but going back to your point that the statute would refer to just New York State, in the same statute, the statute says at B2 that the accusatory instrument was dismissed on any of the following grounds, and that including whether or not it was based on violating the United States Constitution or the New York State Constitution.
And that was my question. I mean, why is that even relevant here? Go ahead.
Because it's because it implicates
In
federal
those
law, and it
cases
shows
where-
that.
in those cases where people are compensated for those kind of violations, maybe a Section 1983 violation or something, that's still something that's happened within the state court. This was a federal prosecution. This was a federal conviction. This was a federal nolle, plea that overturned it. Like that had nothing to do with the state court for which he was aggrieved.
But that's-
other than the fact that you're saying that the NYPD collected evidence.
Well,
And the
like-
NYPD itself, not a state agency.
Well, the lawsuits against the NYPD under this statute, we've cited in the brief, including Fortunato and others. So
Is that an entity you can sue?
under this statute, they can be defendants here whose misconduct has been the subject of relief under this statute. So yes.
Well, also then, under the statute, is ineffective assistant of counsel one of the enumerated factors that would give rise to you using Section 8-B3?
No, Judge Chan, but in our brief, we referenced the fact that the Court of Appeals in Ivy said that it's not, and I'm quoting, it's not necessary that the conviction be reversed on an enumerated ground where there's an acquittal, and further, that the linchpin, I'm quoting again,
It wasn't, here the reversal was on ineffective assistance of counsel. And then to get to where you want, we have to interpret what happened as an acquittal.
well, yes, in effect, yes, but that's what they did in Baba Ali. In Baba Ali, that, again, I'm quoting, the Second Department signaled its understanding that the prejudicial consequences of counsel's ineptitude, the ineffective assistance of counsel, had been heightened by the prosecutorial misconduct. So they looked at the underpinnings, and they said, well, this.
Are you alleging any prosecutorial misconduct here?
We are alleging misconduct by the NYPD, which was
The prosecutor's office, is it?
and the prosecutor's office by placing it first by taking the prosecution over to the federal authorities and then proceeding with it when there was no basis for proceeding with these tainted prosecutions.
Let me just say, I'm not sure why Baba Ali is even appropriate here, because that dealt with, as my colleague said, prosecutorial misconduct that amounted to fraud. But we have your arguments. We certainly gave you way over than 3 minutes.
Yes, and I
because
do
we had so many questions for you, so thank you.
Thank you for your time.
All right. Russell versus Lenox Hill Hospital.
Good afternoon. May it please the court, Patrick Lawless for the defendant, third-party plaintiff, appellate respondent, Lenox Hill Hospital. The plaintiff is not a covered person under a labor law. He wasn't engaged in a labor law type activity. He was merely delivering a machine to the hospital.
It was a machine that was going to be connected to electrical work that had been done previously, correct?
Yes, all the electrical work had been completed.
And when he attempted to deliver the machine, they went to a specific loading dock, correct me if I'm wrong, and the truck didn't fit, and they were instructed to go somewhere else to deliver. Is that right?
Well, Mr. Hernandez, who was in charge of the loading dock, just said to the plaintiff, it doesn't fit. He said, you can attempt to deliver it from the street, that's your choice. That was always the plaintiff's option. And I believe the plaintiff testified that he called his boss, and his boss told him, you have to deliver that now. So that's the facts of the case. There was no
It wasn't an instruction on how to deliver it now that the truck didn't fit in the loading dock.
It wasn't an actual instruction. It was just he gave him he's like, you have the option, and it's up to you to do that.
Now, in fact, the accident didn't even happen on the premises. It happened on a public street, and the machine was supposed to be installed, I think, what was it, on the 12th floor of the hospital lab?
Correct. Correct. And so the accident happened on a public street outside of the hospital, not on the hospital grounds. There was no alteration or construction work going on at the time. The only thing that needed to be done was the machine needed to be delivered, hooked up to the power cable,
The
and then
machine was purchased from a vendor, and the vendor selected the delivery service.
Correct.
So Lenox Hill Hospital didn't have any direct involvement in choosing the delivery service.
correct. And as I was saying, all that needed to be done was it just needed to be hooked up to a power cable, and there was a technician from the company that made the machine that was going to calibrate it, and that was all that needed to be done. All the cases cited by the plaintiff deal with active construction sites where there's construction going on. They're talking about deliveries in the context of an active construction site where the delivery person would be exposed to those types of dangers at a construction site. Here, the plaintiff wasn't remotely exposed to any of those dangers. Therefore, 240 should not have been granted and actually should have been dismissed. Unless there's any other questions, I'll reserve for my reply.
All right, let's see. Any questions? Okay, thank you.
Thank you.
Good afternoon. My name is Evie Kazansky. I represent the third-party defendant, respondent, appellant in this matter. So I represent Rad Source, who was the vendor for the machine. But the issue for the third-party complaint is whether or not, I heard before, discussing whether or not he's an employee or an independent contractor. I think based on this record, it's clear that there was no employee-employer relationship between RAD and the plaintiff. First of all, there's no contract for any indemnity with Lenox Hill. Second of all, it's just a typical, we are asking for a delivery of a product. And then it's clear from the record that even if what the court said was this hearsay statement that the truck shouldn't have been parked where it was parked from this Mr. Monroe, the subsequent situation had nothing to do with any control or supervision by RAD. The plaintiff called his boss, it had to be delivered. Lenox Hill wasn't allowing it into the delivery. So everything that transpired, irrespective of this off-the-cuff possible, you shouldn't really be parking it where it is, does not rise to the level of control and or supervision to make the plaintiff an employee of RAD, therefore to keep the third-party complaint active. And so therefore, we request that the third-party complaint be dismissed. Thank you.
All right, thank you.
Good afternoon, Your Honors. May it please the court. Beth Gehrig for the plaintiff respondent. There are a couple of misconceptions here. First off, this wasn't a situation where the machine simply had to be plugged in and then it was ready to go.
But it wasn't really part of a construction project, was it? I mean, it was a replacement of a machine, and there was a slight modification of the electrical system in order to permit the installation of the newer model of the same machine. So it wasn't a construction project that was larger than the installation of the machine itself, was
I
it?
would submit to you that under Jablon, if making just a hole...
Under what?
Under Jablon, if making just a hole in the wall to run a clock was enough for that to constitute an alteration, here we have that. There is detail in the record.
Counsel, this is, pretty much a white glove delivery service company. They deliver, items to residential and and commercial properties, correct?
Yes, they do.
All right. So the work, by the electrician, it was done prior to the delivery.
There is no indication when that work was completed. In fact, based on this record, there was still additional work that needed to be done once the machine made it up there, and they testified that it was going to take at least 20 minutes. They detailed what needed to be done. It wasn't just a matter of them plugging it in and it working. Essentially what happened here is
What else was required from the plaintiff, I mean, the contract, what was the work? Because I just thought it was just delivery, you drop off, and that's it. What else was required?
well, it wasn't necessarily here respectfully what was required by the plaintiff. The plaintiff was delivering the item that was
But how was his work necessary and incidental to the protected activity? That's the question.
I'm glad you asked. I had emailed both of my plaintiff's defense counsel, and the court was also provided with a copy of the Rodriguez versus Riverside Center Site 5 owner case. In that case, they basically said that because the delivery the driver was making was the very equipment, the very item that was to be installed, there was a sufficient nexus for him to be a covered worker. Here, the machine that is being delivered, and defendant wants to have us believe that this is just a random machine that they do a dozen of these a week. It is a 10-foot high, 5-foot wide, $245,000 machine that weighs over 270,000 pounds that they had to hire a team of outside electricians to start running wires. It is detailed.
But that doesn't, the size of the machine doesn't determine whether there was a construction project within the meaning of the labor law.
Respectfully, Your Honor, the reason why I point to the size of the machine is to show that this was not a routine delivery. This was part of the alteration project. So under Rodriguez, when this court found that delivering tiles that were not going to be installed by the plaintiff who delivered them, but those tiles were going to be installed by other people, made him a protected worker under the law because it was part of the larger project. Here, because the irradiator machine was not just going to be plugged in, there was an additional work that had to be performed. Therefore, it was still part of an ongoing process, and that's where the nexus was. This is not a situation where he was just
Under your argument, any delivery that's made to a construction site, they're covered workers.
Not necessarily, Your Honor. If what is being delivered is something that is not being stockpiled under this court's existing law, if it's not being
So to
stockpiled...
you, it's the equivalent of delivering the machine here is the equivalent of the tiles that were being installed that were delivered in the case that you just gave us on the Rodriguez?
Yes, because the process was still ongoing at that point.
Right, they were installing tiles. Here, they're installing a machine, and all the work for the machine was done other than the machine.
It wasn't all done, and that's the key here. If we look at pages 491 and 492 of the record, they said it wasn't a situation where it was just going to be plugged in, and it
Or it has to be calibrated, right? I mean, it's a special piece of equipment. I just imagine you just don't plug it in, and you wouldn't need electricians for that.
It wasn't just the calibrating. They discussed how there were other things that had to be run. I'm not an electrician, so the technology of that I'm not good at, but pages 491 to 492, they discussed the whole process that still had to take place, and that it was going to take a period of time. I'd agree if all the work had already been completed and you just brought something up and plugged it in, that would be a different situation. But here, when we're looking at the realities of the work and we're looking at the fact that we want to protect these workers, and Lenox Hill said, you can't unload this on our loading dock. They didn't even give him an opportunity to lower it, to show them that he could fit it in. They forced him to unload it outside it where it was unsafe. He didn't have anything to properly.
He also could have brought it back to the shipper, or gotten a different truck.
Respectfully, Your Honor, he couldn't. The contract was for, and this is another reason why this is not a situation like a UPS delivery driver. The contract was for it to be delivered that day at that time. And I think we also have to keep in mind that this was at 10 o'clock in the morning. So whether they had some of the electrical that had to be done later that night, Lenox Hill didn't offer any evidence about when that portion of it had been done. We know that there was still work that had to be completed in order for this alteration to be finished. And if, again, in Jablon, we're talking about a little hole.
But your client is just responsible for the delivery, not about anything else.
He is part of the team that is doing this whole alteration project. If I may, it's
He's altering? He's doing altering?
The team was. So the
I'm
alteration.
sorry, what part of the team is he? I thought he was just a delivery service.
He was, but he was basically hired by RAD. So Lenox Hill, let's say, acted as the GC. They hired electricians to do portions of it. They hired RAD to do it. RAD subbed out this work. RAD was part of that alteration project. RAD had somebody there at the site waiting to receive this machine.
You know, counsel, as my colleague here, Justice Rodriguez, indicated, I don't see the Rodriguez case being really applicable here. What I find applicable is the Tracy case, from this department in 2021. Similar facts. You have a delivery driver who's injured, not performing any construction work. So why isn't that applicable here? Because I think it's full applicable.
I'm glad you brought up the Tracy case, because in our brief, not only did we look at the Tracy case, we looked at the underlying facts in the Supreme Court case. And the reason why Tracy case is not applicable here is the driver there was only allowed to deliver the equipment to the actual loading dock. He wasn't allowed to go any further. He wasn't involved in the installation. There was a different workers.
The driver here didn't have anything to do with the installation either.
But he had to bring it up there where they were waiting for it. It was
He
still
was just told to bring it to another door, essentially. Why does that change the?
Because in Tracy, the work wasn't ongoing. In Tracy, they didn't have the project still ongoing. And in fact, in Tracy, they said if it was the workers who had actually brought the equipment from the loading dock to the place where the work was to be performed, they may have been protected. Listen, I hear what the court is saying here, and I would hope that if you are looking at whether or not he is a protected worker, that you would at least say there's a question of fact here, that we would be able to present this to the jury. And as far as on the 200 claim, Mr. Hernandez told him how to unload. He told him where to unload. The testimony is very clear, and I would just ask this court, because I know you've given me plenty of latitude with the time.
30 seconds.
I'd ask that you look at the testimony at page 310, 311 to 312, where they basically talk about how the manager, which was Mr. Hernandez, which was Lenox Hill's manager, not only told him, go unpack there, he walked him through, showed him how he had to unload, and walked through every stage of it. And the testimony was that he supervised him, because the defendant moved for summary judgment on 200 and we opposed it. The facts should be viewed in the light most favorable to the plaintiff.
Thank you, counsel. Thank you.
Just very briefly, I'd just like to address the fact that.
Counsel, I just have a question. I have two questions, actually. The white glove service, I mean, it's been mentioned, does that somehow heighten the fact that, or how we should look at this particular driver? because he was part of this white glove service that had been contracted for? And then my second question would be is, if in fact there was electricity work that was taking place prior to the delivery, and then necessarily needed electricity work after the delivery, how can we say that his delivery service was a separate phase, easily distinguishable?
Okay, I'd like to address your second question first. The testimony of the Lenox Hill electrician, Mr. LaGrua, I believe it's on pages 572 through 575 of this record. He said the electrical work was complete. There was no additional electrical work that needed to be done. He was asked, when was this work done? And he said it would have been completed prior to the delivery date. Then he was asked, so then the plan was, on the date of delivery, all that was needed to be done was the machine would be delivered, it would be hooked up to the power cable, and then it would be calibrated by the technician. And then he went through the process of actually connecting it, and he described how to connect the power cable to the machine, but that was it. There was no other electrical work. There was no alteration to the structure.
It's like connecting one cable and the machine is connected?
Basically, he was describing the
That's
process
vastly
of
different from what your adversary's saying, right? She's making it seem like something complex needed to happen or some ongoing alteration to get this machine up and running, more than plugging in a cable, more than calibrating it.
No, all the electrical work was complete. All it needed to be done was, and he was describing where on the back of the machine the cable would go and how it would be connected.
Thank you, counsel.
Thank you.
Thank you.
Very briefly, I just want the court to note that the plaintiff has no claim against RAD, and even in their brief, there's no argument against RAD. All the discussions were between Lenox Hill and the plaintiff himself regarding how and what was going on at the street level, and RAD had nothing to do with it. There's no level that RAD considered him employee, and no control or supervision to rise to the level that he should be considered an employee or that we should have any duty towards the situation. Thank you.
Thank you all. Thank you. All right. Corpin LLC versus One Penn Plaza LLC. And let me say that Justice Gesma is recused.
Good afternoon, Your Honor.
Give me 1 second. I have to reset the clock. Thank you. Ready for you.
Good afternoon, Your Honor. Robert Schiffer with Sullivan and Cromwell for Appellant One Penn Plaza, Vornado. There's only one question on this appeal, which is whether the sublease is still in existence. And Justice Billings below correctly ruled that under settled New York law, parties to a contract have the ability and are free, and we have maximum contractual freedom to clarify a contract to affect the parties' intentions, and that's exactly what occurred here.
The intention to surrender the subleases when you paid the $36 million?
There was an error that was made with respect to the characterization of the transaction, and New York law.
That error, characterizing it as surrendering?
Yes, Your Honor. It should have been characterized as it was in the 2022 agreement as an assignment.
That agreement, at the risk of messing up the math, 23 years later, and the parties that were trying to fix this in 2022 were not the ones in 1999.
Well, yes, one of the parties was the same. That my client Vornado was the same party. And then what happened was there was a successor, which was Cap One to Greenpoint. And Greenpoint, Vornado paid $36 million in an auction for this right. And all that the purpose of the amendment was to reflect the parties' intentions. And New York law is quite clear, and we want to encourage parties to correct contracts, and you're allowed to, and there are multiple cases which we cite in our briefs where parties can backdate contracts, where parties can change contractual terms, and that's all that happened here. The other side, in this case, Corpen was not a party to this case. And what Justice Engoron said was, well, that may be right, but then he went and sort of looked at the economics of the transaction and made another error under New York law. So the first error under New York law was he said, well, we just ignore the fact that parties have the ability to restate contractual agreements, and that's long settled law. And the second is that real estate interests can be divided. So if someone owns a building, they can rent an apartment to themselves. And in this particular case, going way back, in 1970, Bowery, which had the two front parcels on this property, leased to itself, subleased to itself for $1 a year for at least that then went for 111 years. And when Corpen bought the property in 1984, it did so subject to this long $1 a year sublease. And then Vornado bought the ground lease on the same property, and that was also subject to the sublease. And what Vornado did,
But that sublease, what happened to that sublease in 1999?
in 1999, the sublease existed. Vornado entered into an agreement to purchase the sublease when there was an auction, and it purchased the sublease for $36 million.
And then rights were surrendered?
It did that, but then it corrected it as it was entitled to under New York law in
2022, it
Correct.
attempted to correct
yes,
that
and
error.
New York law encourages those kinds of corrections. That's good public
Well,
policy.
I have a question. I want to go back to the 1999 surrender. Did it have any, provisions even permitting, the parties to revive the sublease sometime in the future, or even to allow third parties to, revise the,
Yes, it did.
the sublease?
Yes, it did, Your Honor.
Where?
In Section 3, the sublease had an ongoing the agreement, the purchase agreement, parties had an ongoing obligation to, quote, take such further actions to more effectively assure the realizations of the full benefits of that agreement. In addition, Section 4 of that agreement said that Section 3, this provision that allowed the parties to restate the agreement, survived the surrender of the agreement. So the parties contemplated exactly the circumstance that occurred here, and the parties and Vornado had the right to obtain the full benefit of its agreement. The other side wants a windfall here, Your Honor. They purchased the property subject to both the ground lease and this $1 a year sublease, and just by the fortuity of the fact that the purchase of the sublease by Vornado for $36 million was not properly characterized, they like this windfall, and that makes no sense. Vornado recognized in 2022 that there was an error that was made back in 1990.
Why did it take so long?
Excuse me?
Why did it take so long?
There's nothing in the record about that, Your Honor, but New York law, look, if we
You
corrected
could surmise why it took so long, but you're right, there's nothing in the record.
if they'd corrected the error in 2 weeks, no one would have said there was any issue with that.
Because that's different.
No, but
Right? If you make an error and you say, oops, I made an error, and it's a day, 2 days, 2 weeks, maybe even a year.
Right, this was recorded already.
But there's nothing in the record that Corpen relied on anything that Vornado did. They were not a third party.
So there was a novation, and then you're saying you can always do away with what was terminated and just revive it.
You can under New York law, Your Honor, and New York law allows for maximum contractual flexibility, and the parties here actually provided for in the purchase agreement when Vornado paid the $36 million for the fact that in the case the seller, which was Cap One, had the obligation to restate the agreement to affect the parties' intentions in doing this deal.
Thank you, counsel. You have time on rebuttal.
Good afternoon, Your Honors.
Good afternoon.
Brett Dockwell from Haynes and Boone LLP for plaintiff respondent Corpen LLC.
Your adversary says this was a mistake. It was a mischaracterization. New York law encourages parties to be able to fix this. How do you respond to that?
Okay, in the first case, that is a mischaracterization. We have in the record why this was changed in 2022, because appellant told us why, and that's found on 516 in the record, when appellant's counsel says the reason that we tried to revive this sublease 23 years later is so that we wouldn't have to pay rent on land we were using from the respondent. So this wasn't an error, and I'll submit to you, even if it were an error, that's a question of fact. There's nothing in the record that establishes as a matter of law that it was an error. So on a motion to dismiss, that alone would be grounds for affirmance of the order below. But in terms of freedom of contract, This case is not about freedom of contract, Your Honor. There is not a single precedent in which the principle of freedom of contract has been employed to abrogate the rights of a third party. And that's what they're trying to do here. In 1999, they terminated the sublease. It was not a mistake. It was a $36 million transaction. These were well-counseled parties. These were sophisticated parties. They signed a surrender agreement. They even went so far as to record it on the property records, signed and notarized. This was not a mistake. That's what they intended to do. And under settled New York law, the surrender of a sublease is a conveyance of real property. And once a conveyance of real property is made, is done, the right is extinguished. It cannot later be revived. We discussed this in our brief. Once that was terminated in 1999, my client had the right to be paid for the property that it leased to the appellant. They're now trying 23 years later to come back and to abrogate that right. Just one further thing, the definition of lesser sublease we respectfully submit controls this case and is sufficient grounds for affirmance.
Thank you.
Counsel, can you respond to your adversary's statement that the surrender of the lease cannot be undone because that's a transfer of property?
It certainly can be, Your Honor, and all we're doing is recharacterizing the transaction. They cite no case to the contrary, and in fact, Justice Engoron cited no laws in his decision. We think Justice Billings had it exactly right. The New York law allows a party to correct a mischaracterization of a transaction. And in fact, what happened here, and this is important in terms of the equities, the unfair aspect of this result is if this court does not reverse here and does not go down the road that Justice Billings did, because they bought this property in 1984, the other side, Corpen, knowing full well that there was a sublease. The sublease was going to go out for many, many years, and it was for $1 a year. So they got that property for a discount. Vornado bought the ground lease on the property subject to the sublease and did so also knowing full well that there was a sublease in place. Vornado, at an auction in 1999, that was a competitive auction, paid $36 million to acquire the sublease. And by doing that, obviously Vornado got control of the whole property. But in terms of figuring out, well, what's the rent that Vornado should pay? Well, Vornado is now being forced to pay twice. It paid the $36 million and now has to pay rent on a sublease parcels that these folks, when they bought the land in 1984, knew they were buying it subject to the sublease.
Vornado is now renting to Walgreens and
That's correct, Your Honor. But the
other
key
stores
point,
around Penn Station.
but it's entitled to do that as a landlord. Again, real estate interests can be subdivided. There's nothing wrong with that. Justice Engoron thought that you couldn't, but there's the anti-merger rule, which clearly applies in this case. And like I said, you can own a building and sublease an apartment to yourself. So you go back to the original transaction in 1990. Bowery divided up this property into the underlying fee and then also the sublease and then the ground lease. And what Vornado did, it could have done nothing. Now, if another party had won that auction and purchased the land in 1999 under the other side's theory, Vornado would still have to pay full market rent for the sublease portions that it did not own.
Counsel, this is a 3211 motion,
Yes, it is, Your Honor.
so presumably more discovery might lead to the intent behind the purchase and how you're indicating? I mean, can we make all of these findings as a matter of law on what you're saying right now?
The only issue really before the court is whether the 2022 agreement is a valid agreement and whether that somehow violates New York law. And New York law wants to encourage parties to correct errors that are made in purchase agreements and any other contract. And there's nothing wrong with doing that. New York law encourages that. You don't need to get parole evidence
How
to
does
it.
your intent, when you did what you did in 1999, play into that? Should we be considering intent with regards to my colleague's question?
Not at all, because I think it was a mistake that was made. Again, if it had been made 2 weeks after the deal, we wouldn't be here today. And all you have to do is say, is the 2022 agreement a valid agreement? Because if the sublease is still in existence, we win. That's a legal decision for the court to make. Now, the one last point I'd like to address, because the other side raises this theory, which makes no sense, that somehow the sublease disappeared in 1984 when they acquired the land. And that makes no sense. Vornado paid $36 million.
Is it when they acquired the land or when you surrendered it?
No, the surrender was not, the surrender, we could revert back on the surrender, but the sublease itself makes quite clear in paragraphs 1903 and 3103 that the sublease could be assigned, and that's exactly what happened here when Greenpoint Savings.
To be clear, counsel, subleases can be surrendered.
Yes, they can be, and they can also, but in this case, you're entitled to, and we cite the cases in our brief, under New York law, you can correct a mischaracterization of an original transaction.
Devil in the detail, right? Because if it's concluded that your intent was to surrender it in 1999, then why are we letting you revive it in 2022?
Because it's not about what our intent was. We entered into an agreement. It was not properly characterized, and the only question that's before this court is did the parties, did Vornado and then Cap One, which is the successor of Greenpoint, have the ability to restate their agreement to correctly reflect.
New York law encourages that.
And our point would be not only does New York law encourage it, other cases have found that you can, for example, backdate a contract. You can change the terms of a contract after the fact. So again, the only parties to the 1999 agreement are Vornado and Greenpoint. The only parties to the 2022 agreement are Vornado and then Greenpoint's successor, Cap One. And those parties had the ability under New York law to restate their agreement to properly reflect what the parties intended. And as reflected in the agreement, which is the 1999 sales agreement.
Thank you, counsel. Thank
to
you.
reflect
Thank
the
you all.
economic benefit. Thank you very much.
I'm waiting for Justice Guzman to come back. AlphaSense Inc., Financial Technology Partners. You may begin. Thank you.
Good afternoon, Your Honors, and may it please the Court, Jed Bergman of Glenn Ager Bergman Fuentes on behalf of Defendant Appellant FT Partners. Your Honors, I'd like to make two key points on why this Court, on de novo review, should reverse the decision below and enter declaratory judgment for appellant. First, the language of the key man provision is unambiguous. It is only triggered if Mr. McLaughlin ceases his role of actively leading or co-leading the team, providing advisory services to AlphaSense, and was critical.
Actually, doesn't it include the term actively?
It does, and
And that's a very subjective term, isn't it?
I don't, well, so.
I mean, it seems to me as a trial judge, if I had to determine whether something was done actively or not, that would be very difficult to do on a record without a hearing about what that meant. So tell me why any clause with the word actively in it doesn't require a trial to determine the merits of the claim.
Certainly, Justice Gessmer, happy to. This is a 3211 motion to dismiss, and so if there were allegations in this complaint about leading and ceasing to lead and whether the leading had been active or not, that might give rise to an issue of fact. But there's a critical distinction here between two different things, actively leading the team and providing the services. The team provides the services. All of the allegations in the complaint about what didn't happen here relate to providing advisory services, investor introductions, investor meetings. Those are all covered by Section 1 of the contract, which is what the team, the FT Partners team, is supposed to do. Section 6, which includes the word actively, is about Mr. McLaughlin's role and whether he ceases actively leading the team. But there are no,
I don't understand why it can't be read as actively leading the team in the provision of services. I mean, you know, why can't it be read that way?
Respectfully, A, that's not what it says, and we believe there is a distinction, and that distinction is not only textual, there are two different verbs. Actively leading applies to the team, and the team is providing the services. There's a structural distinction as well between Section 1, which is all about services, which never mentions Mr. McLaughlin by name at all. And Section 10 allows FT Partners to provide services through affiliates, which is further proof that there's no personal obligation on Mr. McLaughlin to be involved in providing services. Section 10 is page 40 of the record, Section 1 is at 37, and the key man provision, of course, is at 35. key man provision, of course, at page 37. This is not a personal services contract. And under the unambiguous language, the issue is not, the issue on the key man termination is, was there a cessation in the role of actively leading the team? This complaint on de novo review.
So, let me just see if I understand. Your position is that no matter what he was, no matter what he did, as long as he was, let's say, the figurehead of that team, that's fine. That's actively leading or co-leading.
No, Justice Pittsburgh, not at all. Actively leading means actively leading, but this complaint does not allege anything about Mr. McLaughlin leading. There's no allegation that he retired, went emeritus, leadership transition.
Well, there were allegations that there were meetings that he was supposed to attend that he stopped attending, right? Were those allegations inside the complaint?
There are allegations that he did not attend investor meetings, but A, that relates to providing services. Meetings is covered by Section 1B. There's actually no allegation in this
So
complaint.
as long as someone else attended the meetings, that's fine because he was still actively leading the team.
They're separate activities. There's no allegation in this complaint that Mr. McLaughlin was asked to attend a meeting that he did not attend. There's no such allegation in this complaint.
What about the allegations in the complaint that McLaughlin was missing in action, that he was functionally incapable of providing the feedback that and advice that AlphaSense needed, that he effectively abandoned AlphaSense? I don't understand why those aren't good enough on this kind of motion.
So effectively abandoned AlphaSense and mission.
As an example, that wasn't exhaustive.
Understood, Justice Gasmer. Allegations like that are conclusory. There are no facts. There are no facts that say, we asked him to come to this meeting and he didn't come. We complained he wasn't leading and he didn't get better. There's none of that. All of the allegations are about services that he didn't provide, and that's not.
Which part of our pleading rules require that kind of detail in this kind of complaint? This isn't a fraud complaint.
Not a
It
fraud
requires
complaint,
detailed
but-
allegations. Why aren't those good enough in this kind of complaint?
They're not good enough because the contract draws a clear distinction between providing services, which is what the team does, and leading the team, which is what Mr. McLaughlin does, and those allegations all go to providing services. I'll reserve the remainder of my time for rebuttal.
Thank you.
Good afternoon, Your Honors. May it please the Court, Megan Sullivan of Zeisler PLC on behalf of Plaintiff Respondent AlphaSense. The Supreme Court correctly applied the
Should we read
well-established.
actively lead?
I'm sorry, Justice.
Should we interpret actively lead?
It's a subjective term, Your Honor, which is why there's a fact-based inquiry that still needs to happen down the road. I think it's pretty clear that the Supreme Court applied the very well-established standard on a motion to dismiss, and that this court should affirm that ruling. What FT is really doing here with respect to their claim that the court considered extrinsic evidence is they're really making a much more fact-based inquiry, right? FT is saying that the Supreme Court looked at whether the allegations were that McLaughlin was actively involved, quote unquote, in AlphaSense's engagement instead of whether McLaughlin was actively leading or co-leading the team. And at one point, FT uses the word grafted on page 20 of his brief and says the Supreme Court incorrectly grafted an active involvement requirement, but that's actually not what happened at all.
How do you respond to your adversary's distinction between actively leading and providing the service?
I think to be honest, Justice, I think that as a threshold matter, the reality is that for those of us who haven't lived with this case for 18 months, the phrase actively leading or co-leading the team providing the advisory services to the company doesn't really roll off the tongue. And I think
Speak more directly into the mic, please.
I'm sorry. Oh, sorry. I'm sorry. I was probably leaning away. Thank you. As I was saying, the phrase actively leading or co-leading the team, providing services, doesn't exactly roll off the tongue. And so I think when the court uses the phrase active involvement or was actively involved, it's really a semantic shorthand without a difference. And so when I think that in claiming that there's a critical difference between those two terms, FT is really asking this court to endorse its interpretation that McLaughlin could have been actively leading or co-leading even though he wasn't actively involved. And I think that's not the court's role on a motion to dismiss. Now, FT's reply brief actually summarizes this at page 10 when it says the concept of active involvement and actively leading or co-leading are not the same thing. But again, that's not a ruling that the court can make as a matter of law on a motion to dismiss. It's a very fact-based inquiry. And having conducted a year's worth of discovery on this very point, I understand why FT wants to make that argument, but again, that wasn't a ruling that the court could make as a matter of law on a motion to dismiss. FT also makes an argument with respect to the ambiguity and says that the lower court found that the contract was ambiguous, but I think it's really important that this court recognize that that didn't happen. The lower court never found that the engagement letter was ambiguous, never uses the word ambiguous or ambiguity in its ruling, and I think that's a really critical misstatement that FT made in its opening brief. FT also makes the final argument that the court erred in finding that we needed to make, the court erred in finding that we were required to identify a particular moment in time when McLaughlin ceased actively leading or co-leading the team. But as the decision correctly noted, defendants at page 7, defendants do not substantiate this proposition with precise contractual language or case law. And the reason they don't do that is that the contract actually has language that undermines that argument, because as the court described on page 5 of the decision, the agreement explicitly permits termination at any time if McLaughlin ceases actively leading or co-leading the FTP team and does not require immediate action. So that's an important point in response to FT's final argument. The one thing I wanted to say in response to Mr. Bergman's comment on his opening argument, and he said that to the extent that AlphaSense actually alleged that McLaughlin ceased actively leading or co-leading the team, we'd be in different territory. And if the justices are looking for those exact allegations in AlphaSense's complaint, they're found at paragraph 7 of the complaint, where which says McLaughlin, quote, ceased his active involvement in leading the team, and paragraph 48 of the complaint, where we say McLaughlin did not satisfy the condition that he was leading or co-leading AlphaSense's engagement with FTP. Now, FT dismisses those allegations as conclusory, but it can't be that when we use the language from the contract, they're conclusory, but when we say active involvement, we're changing the meaning of the contract.
Thank you, counsel. Thank you.
Your Honors.
Your Honors, this is de novo review of a contract case, and the analysis starts with the very first question in any contract case. Is this contract unambiguous? Looking at the four corners, what does the plain meaning tell us? There's only one party that has put a dictionary definition of leading in front of this court, and that is FT Partners. And leading means, this is quoted at page 13 of our reply brief, leading means directing the operations, activities, and performance of, in this case, of the team. The team provides the services. Mr. McLaughlin leads the team. AlphaSense has never offered a contrary interpretation. The Supreme Court never used the word plain meanings, never used the word ambiguity or unambiguous, did not do this analysis, but this court does it on de novo review, and every word has to have meaning. To read this contract as if it says that Mr. McLaughlin must lead the team in the provision of services is to rewrite the contract. That's not what it says. That's not how New York law reads contracts, and AlphaSense does not get to rewrite the contract to suit the allegations that it made. The two paragraphs that counsel referred to, paragraph 7 says two different things. First, it says that Mr. McLaughlin's promised involvement, advice, negotiation, engagement, and so on ceased. That's what their complaint is really about, the pre-contractual promises. And then they tack on, as did his active involvement. Same in 48. It's just conclusory. It is just a restatement of what's there. It is not enough to parrot the words of the contract. Even on a 3211 normal pleading standard, you need to allege facts. There are no facts about ceasing Mr. McLaughlin's role of leading. The facts that are alleged are about the failure to provide advisory services. And because this complaint fails to state a claim under the unambiguous standard, the proper remedy for this court is to enter declaratory judgment in favor of FT Partners, declaring that there was no key man termination here. Thank you.
Thank you both. People v. Perez. Let me begin.
Good afternoon, Your Honors. Isabel Patkovsky on behalf of the Legal Aid Society for Mr. Perez. Everyone agrees that Mr. Perez's lawyer signed the SCI waiver off the record. That's a straightforward violation of CPL 195.20, and so the plea must be vacated. This is in many ways an example of how not to do an SCI plea virtually. We recognize this was during COVID. It was a virtual hearing. Perhaps the court could have cut some corners, maybe. But here, not only did Mr. Perez not sign the waiver himself, but his lawyer avowedly did it on a date, an unknown date, before the plea proceeding. And that makes this case pretty much entirely analogous to Trapani, which was a third department case, where the court specifically referred to the waiver having been signed.
We've decided this already, right? We've decided this in People versus Smith?
Yes.
It's clear.
Thank you, I agree. I'll move to my second point then, which is that even beyond the vacating of the plea on the grounds of the SCI waiver, there really were some other significant problems with this plea. And the biggest issue was that the court failed to explain that even though the court was closed, Mr. Perez had the right to an adjournment. And this is a critical distinction between this case and other cases involving virtual pleas. We're not contesting that the court had the right to take Mr. Perez's plea on Teams or on Zoom or on whatever it was. But Mr. Perez had to know that if he wasn't comfortable with that, he was allowed to get an adjournment. And this record shows just how problematic many of these virtual pleas were. Through no one's fault, Mr. Perez dropped off of this plea twice. The first time he was cut off because of jail time limits, jail booth limits. The second time, the connection just seemed to fail. And he really had the right to know that he didn't have to do it this way.
And there were no executive orders or modifications of the statutes that were in effect that would have modified the requirements of the CPL at all?
Not at all, Your Honor. There was a modification which allowed a felony plea to be taken virtually, but it certainly did not remove the consent requirement. And then finally, on the order of protection, this is another instance in which this case is really analogous to a case that this court already decided, People v. Calderon. This is a case where an order of protection was issued in favor of someone that Mr. Perez had never met. She was the custodian of a church that he had burglarized. The prosecutor, in fact, didn't even really seem to know who she was. And in Calderon, there was exactly the same situation. The order of protection was in favor of a building custodian. That's just not what orders of protection are for.
Provided for issuing the order of protection in favor of the custodian in this case?
There was no basis given. The court never gave any basis. The prosecutor did not give any basis.
Again, request that order of protection?
The prosecutor did request it, yes. And again, this is just a straightforward violation of the criminal procedure law. This plea really cut too many corners for it to be valid. Thank you.
Thank you.
Good afternoon, Vincent.
Just give me a moment, thank you.
I'm sorry.
You can start, thank you.
Good afternoon, Vincent Revelisi for the People. I think
So, counsel, how do we get around, our decision, Smith and CPL 19550? How do we get around that?
I think Smith is extremely different factually because in that case, the SCI was mentioned several times during the plea proceeding, but the signature was never mentioned during the plea proceeding. The court didn't ask the defendant whether he signed it or wanted to sign it, so it wasn't clear when or how it was signed, and the date was different, so that implied that it wasn't.
The crux of the decision is that it's an open court requirement, right? That's an indispensable requirement. Here, are you saying that it was signed during that virtual meeting's not the right word, but a virtual hearing?
I think that there's a good inference that it was, and that there's no evidence that it wasn't, because there were two virtual proceedings where it was discussed, and at both of those proceedings, the SCI was mentioned and the signature was mentioned. In the first of those proceedings—
Right, but according to the law, he had to sign in when he was taking the plea, right? If he signed it—
in open court, but not while he was taking the plea necessarily. That's not what the actual statute just says, in open court. So it was signed in open.
But I think that Smith, when you take our reading of Smith, I think that we understand it's in open court the day he's taken the plea, right? Because then if not, then Smith, what is Smith about?
Well, I think the problem in Smith, because there was a different date on the form, and there was no reference to the signature in Smith as to the signature during the plea proceeding. So there was no reference to when it was signed.
Is there a different date on the form here?
There is, yes, but here the plea is actually discussing the signature, both at the plea, and there were two pleas here, really, because the first one had to be abandoned when they took the defendant out of the virtual proceeding in the middle of the plea. It was after the SCI had already been completely gone through and approved by the judge. The defendant had talked about, I agreed for my attorney to sign it, my attorney agreed he would sign for me. So that was all discussed right there in what you would call virtual open court, because if open court
The
doesn't
previous
include,
date.
on the 17th, correct. So not on the same day as the
What
plea.
you're saying is that if a court starts an allocution on a guilty plea on day one, and it falls through for whatever reason, whether it's technology, something else, defendant signs it on day one. Let's assume that's true for what I'm about to ask. When you start again on day two, you could just keep going from day one. So what the signature from day one counts?
Well, if not, then we lose. I agree. But I think in this case, on the 17th, when he signed it in open court, that does satisfy the open court requirement. And it was clear that it was in open court that they
You're
discussed.
saying that the reference to the prior day one date is just error, irregularity? I don't understand. What do we make of that other date?
I'm sorry, the first date? Well,
Right.
the first date, the SCI happened, and it was repeated on the second date, but it was already signed. So if you were to,
It was signed on the earlier date, you can see.
yes, in open court, but on the earlier date. Yes.
What happened on the first date? Why didn't the SCI go through? Because clearly it didn't go through.
Well, the judge approved it, but then they didn't finish the plea, and the reason they didn't finish
See,
the
I'm not sure I understand what you mean that the SCI happened on one day and the judge approved it, and then it didn't, because I mean, I've taken pleas in criminal court, and I don't know if we're jiving right now.
Okay, the SCI, it could happen. Somebody could waive indictment and go to trial if they wanted to. But in this case, that's not what was agreed and not what happened. But the SCI was done, and at the time that the defendant was in the middle of his plea, they took them out from the virtual proceeding because they had a time limit. And everybody said, oh, no, now we have to do
So
this
when
again.
that happens, you have to start again.
And they did, but they used the SCI that had already been signed.
They didn't start
Not
again.
starting again.
So that was February 3rd, the day it was signed, February 3rd, 2021.
Actually, we don't know if that's the day it was signed, but that is the day it was dated. But during the,
It's another problem, right?
yeah, it is. Well, that's why it's a little bit unclear and why we have a good
Why is
argument
that then
instead of.
good enough? If we don't even know that the date on it was the date it was signed, it was certainly not the date that the SCI, that the waiver was completed. So how can that be good enough?
Well, from the conversation that happened on the 17th, which was the plea proceeding that they intended to do when they couldn't finish because it was ended by the virtual proceeding. So on the 17th, there was discussion both of the attorney agreeing to sign it for the defendant.
Why isn't it more acceptable for the court then to say, we need to now start again with the SCI paperwork and start from position one, as opposed to starting in the middle?
The court could have, and obviously if the court had, this wouldn't happen here, but the court could have done the entire thing over from scratch and had everybody sign
Question is,
again.
Must the court do it over? Because the signature, the reason that we have the signature and this requirement is to ensure that the defendant knows that what he's doing, he's waiving prosecution by indictment knowingly and intelligently. So the way you're asking us to do is to sort of break that into pieces where one happens weeks before, the other happens 2 weeks later, and then somehow we're supposed to be comfortable that the defendant understood exactly the rights that he's waiving.
The discussion happened both times, though. So he was informed of the rights of grand jury, of having an indictment instead of an SCI.
That may be true, but the signature, which is indispensable according to Smith, didn't happen both times.
It didn't happen both times, but it was referred to. His previous signature that he signed was referred to again at the final proceeding where it was successfully completed. So it was referred back to, it's the same person, it's the same attorney, it's the same form, it's the same signature. He's referring back to the thing that he signed several weeks before. So whether he would know would not change. He would have understood it extra because he was told everything twice. And the signature didn't happen again. Had it happened again, we'd have nothing to argue about, obviously. So that's unfortunate, but it's not like he wouldn't have understood when he got to hear everything twice, and he was only looking at his signature from weeks ago. But it doesn't say in the open court requirement that it has to be at the same time as the plea.
Thank you, counsel.
Thank you.
Very briefly, I'd just like
Counsel,
to,
how do you respond to that, the statute doesn't say that it has to happen on the same date?
so the statute does not say that it has to happen on the same day. I would agree that Smith seems to suggest that it does have to happen during the plea, but even if it could happen at another proceeding in open court, the one point I would like to clarify is that we actually don't know when this waiver was signed. The prosecution is surmising that it was signed at a previous
I
appearance.
think there might have been a mild concession to that, right? Because the comeback to one of our questions was, it's dated the what is it, February 3rd, but we're not sure when it was signed.
It's dated February 3rd, which is not a date that there was any court appearance. The only thing that the court says about it, and this is page 10 of the plea, is I do have the waiver of grand jury that's been signed. That's
Well,
it.
So what we know is that it was signed.
We know that it was signed. That's all that we know.
When, we don't know, or under what
Exactly.
circumstances, whether it was in court, whether it was in Rikers, whether it was somewhere else.
That's exactly right. Thank you.
Thank you. Wells Fargo. You may begin. Thank you.
Thank you, Your Honor. May it please the court. Midland's complaint is based on an alleged breach of Representation 37 in the mortgage loan purchase agreement, which states in relevant part, to seller's knowledge, there is no material default under the related mortgage loan. So to allege a breach, Midland has to allege, one, a borrower's material default, and two, UBS's knowledge of that default prior to making the representation. The default in question that they allege is that the borrower for the Beach Hill loan falsely represented to UBS that it had no existing debt when in fact it had an unsecured debt to another party. The complaint alleges nothing about seller's knowledge and should have been dismissed on that basis. Seller's knowledge is a defined term in the agreement, which is the actual state of knowledge of the seller without having conducted any independent inquiry and without any obligation to have done so. There is no allegation in the complaint that UBS had actual knowledge of this undisclosed debt, none.
There was a mortgage file. Did it contain that particular loan debt?
No, Your Honor, but you're correct. What Midland is relying on here is a provision in the purchase agreement that says UBS is deemed to know information in documents that are contained in the mortgage file. Mortgage file is a defined term that includes 19 specific types of documents. It's not all documents about a mortgage loan. It's not even all documents that UBS provides.
Isn't this something that UBS would be looking for in its due diligence when it's entering into this mortgage?
I'm sorry, Your Honor?
Isn't this something that UBS would look for to see if there were prior mortgages or encumbrances that are relevant?
I would expect it would be, Your Honor, but that's not the point. The question here is, did UBS have actual knowledge of that undisclosed
Why
debt?
is actual knowledge required?
Because the representation is made to seller's knowledge, and to seller's knowledge is a defined term, which says it is the actual state of knowledge of the seller, that's UBS, without having conducted any independent inquiry and without having any obligation to have done so. So that is actual knowledge. It's not constructive knowledge. Any argument that they should have discovered it is insufficient in order to state a breach of this representation and warranty.
So here we have Representation 37, defendant represented to its knowledge there was no material default, that the documents required to be a part of the mortgage file were deemed within defendant's knowledge, and that the debt would have been disclosed as part of the mortgage file. So why is that insufficient?
Because the document that Midland relies on is the promissory note for this undisclosed debt. That promissory note is not one of the documents required to be in the mortgage file for multiple reasons.
Counsel, I'm sorry, do you mind if I?
No.
Could you also address your statute of limitations argument?
Yes, Your Honor. Can I just answer this question?
Yeah, please.
Thank you. Promissory note, what Midland says is that the promissory note for this undisclosed debt is included in the mortgage file subsection 12, which includes any loan agreement relating to such mortgage loan, meaning the Beach Hill loan. The promissory note is not a loan agreement. The only note that is required to be in the mortgage file is the note for the Beach Hill loan itself that evidences the borrower's debt under the Beach Hill loan. Even if you could consider a promissory note to be a loan agreement, the promissory note for this undisclosed debt is not a loan agreement relating to the Beach Hill loan. The promissory note is unsecured. It has nothing to do with the Beach Hill loan or the mortgage property. And when the parties intended a document that relates to a borrower's other existing debt to be included in the mortgage file, they said so expressly. Subsection 11 includes any intercreditor agreement relating to existing debt of the borrower. So by using existing debt of the borrower in one subsection and not using it in subsection 12 that Midland relies on, parties clearly meant different things. Your Honor, to answer your question, so there's really no dispute that if the plaintiff residence rule is applied here, as it was by the Court of Appeals in Deutsche Bank versus Barclays, the complaint was filed too late. What Midland wants the court to do is deviate from the plaintiff residence rule because a single certificate holder, KKR, is allegedly a New York resident. And no court has done this. And courts that have applied Deutsche Bank have consistently read it as stating that where trust beneficiaries are geographically scattered, the plaintiff residence rule applies.
Thank you, counsel. You have time on rebuttal. Thank you.
May it please the court, Eric Fisher on behalf of plaintiff respondent. I'll begin with the statute of limitations point, since I know that that was of interest to your honor. The statute of limitations had not expired. Both parties here agree that assuming New York's statute of limitations applies, this case was timely filed. And what this case involves is essentially stepping through a door that the Court of Appeals in the Deutsche Bank decision very expressly left open. The Court of Appeals in Deutsche Bank noted that the parties in that case, which was a residential mortgage-backed securities case, they had agreed that the residence of the certificate holders was just too difficult to discern because of the geographic dispersion and other characteristics of the certificate holders. And then the Court of Appeals noted, quote, in light of that agreement between the parties, we do not consider whether the residence of the certificate holders is an appropriate basis for determining the place of economic injury here, or whether the residence of trust beneficiaries may be relevant to the place of economic injury in a different case. This, your honors, is that different case, which is why the case was timely filed with a New York 6-year statute of limitations.
Well, why wouldn't we look at the trustees' resident, or Wells Fargo, or I think it's Midland Loan Services, so either Utah or Kansas?
Right, that is what my adversary argues here, either Pennsylvania or Kansas. But either way, it's true, we would agree that under those statutes of limitations, this is not a timely case. But here, there is evidence in the record that the directing certificate holder, not just any certificate holder, the directing certificate holder that has rights under the relevant pooling and service agreement with respect to the direction of this litigation is a New York resident.
Midland was the one that was has the right, was authorized to enforce.
That's right, Your Honor. Midland is the quote-unquote representative plaintiff. Midland is the special servicer to this trust, and Midland is authorized to bring this repurchase claim on behalf of the trust. But here, the evidence is Midland will not suffer any loss, and that's clear. I think my adversary tries really hard to make it seem that Midland may suffer a loss. The best he can do is say Midland has quote-unquote skin in the game. The loss here is suffered by KKR, which is the directing certificate holder, resides in New York, and it is also undisputed that they suffer the first loss. There's evidence in the record, for example, that the directing certificate holder here holds $25.9 million of certificates. We're talking about a $27 million loan. It is very reasonable to presume that they may be the only loser to suffer losses here. So we have identified—
KKR is not the only certificate holder. I mean, there are other certificate holders, and I don't recall seeing anything in the complaint you saying that KKR was the only, entity, who suffered losses.
No, Your Honor. We think that there's reason to believe that that will be the case, and KKR is the only certificate holder with rights to direct this litigation.
I mean, clearly you said that they were not the only injured party, right?
They're not the only certificate holder. They may be the only certificate holder who will suffer a loss here.
I mean, certainly they purchased the most junior classes.
Exactly. They bear the first loss, and that's undisputed. And I think in general, and this goes to the merits argument that's being made as well, what's being confused here is pleading and proof. There is more than enough here to apply New York statute of limitations, and I think that that's why Justice Bannon properly reached the merits and did not find that there was any statute of limitations problem here. If my adversary wants
She
to...
didn't discuss that in any length in her decision, correct?
She didn't discuss it at all, Your Honor. It was argued extensively, but she did not discuss that issue at all. If my adversary wants to argue at the conclusion of discovery, when the facts will be clear as to whether KKR, the New York resident, is the only certificate holder to have suffered injuries, he can renew that motion at that time. And it is typical that when statute of limitations questions involve those kinds of facts.
Isn't that type of analysis exactly what the Court of Appeals didn't want us to engage in under Deutsche Bank?
Your Honor, I don't think that that is what the Court of Appeals was warning against. The Court of Appeals was very specific about what it was warning against. It was warning against a complicated interest
Sense of gravity, right? And an analysis of where the injury, whose injury is worse.
Yes, but that's not here. KKR is the only the directing certificate holder, New York resident, likely to bear all of the losses. What the Deutsche Bank court was warning.
Saying likely to bear all the losses. That's not too comforting.
Well, that's part of proving damages, Your Honor. I mean, that's often not going to be resolved until the end of a case.
Thank you, counsel.
Could you start where counsel left off, addressing how KKR status has an effect on the statute of limitations issue?
Yes, obviously, our position is that it shouldn't have any effect. But I want to talk about the injury here. The injury that's alleged in the complaint is a material and adverse effect on, quote, the value of the Beach Hill loan and the interests of the trust and the certificate holders in the Beach Hill loan, because the undisclosed debt, quote, negatively impacted the financial condition of the borrower to the detriment of the trust. And I think the way that Midland phrased that is significant, and because when there is a material and adverse effect on a loan that is serving as collateral for all certificate holders, that's increasing the risk for all of them. They have different payment priorities, clearly, but I would be shocked if any senior bondholder said that the default in the collateral backing their loan wasn't an injury to them, just like it would be to others. And which is a point we make on our brief as well. There are other classes of certificates that are entitled to payment after other certificate holders are paid off. They don't suffer losses because they only have a notional principal balance. But every dollar of loss is a loss to that certificate because they're waiting to get paid until the end. Also, as far as KKR being the directing certificate holder, the fact that they are directing Midland to file this lawsuit doesn't alter the nature of their injury or give them a greater injury than other certificate holders. The point is that there is an alleged impact on the collateral that backs all of the certificates.
Thank you so much. Thank you both. Cola v. City of New York.
Good afternoon, if it may please the court. Jimmy Wagner for the plaintiff appellant Margel Cola. This lower court in this scenario converted a summons and complaint into a special proceeding. Then once it converted it into the special proceeding, it then applied a 4-month statute of limitations. That was the very request that the respondents requested of the lower court. However,
But why wasn't it brought as an Article 78 in the first place is the question.
because this wasn't an Article 78, Your Honor. This was a New York State and New York City, primarily a human rights claim of discrimination. There was an Article 78 proceeding, and Justice Hagel was the same judge on that Article 78 proceeding. Justice Hagel remanded it.
Hagler, do you mean?
Hagler, I apologize. Hagler remanded it. And after it was remanded, it was, the city changed its decision, which is not part of this record. And that's fine. And the lower court in the Article 78 said we have to defer to the agency, just as Justice Gesmer and Justice Pitt-Burke, both of you did in Marstella, right? Marstella, you gave the city a method and a mechanism by which they could comply with the New York City Human Rights Cooperative Dialogue under the constrained emergency of COVID. You said, we're not going to go by the definition of cooperative dialogue. We will allow the city to handle these 6,000 applications in this emergency mechanism. And that was perfect, and that's the law. However, this case is more aligned with Hoskins versus Memorial. This isn't an Article 78. What's alleged here is that the discrimination occurred not at this panel that was authorized by this court in Marstella. The discrimination occurred back at the NYPD level by Mr. Melikowski. It is alleged that Mr. Melikowski predetermined Mr. Marshall Kohler's denial of his religious accommodation based on his religion.
Let's go back. So, remand. There's, a hearing, and then Justice Hagler denies the relief. He denies the petition. And it seems to me that those claims on the remand are the same here.
So, Your Honor, it's absolutely impossible for my client to obtain the relief he's requesting in an Article 78 proceeding. The Article 78 proceeding is just about the agency's determination whether it was arbitrary and capricious. This court has time and time again said during COVID, what the city did was not arbitrary and capricious. And I would like to point you to respondent's brief, page 12, and it's in a footnote. What respondent writes is, but since Kohler asserts claims on the anti-discrimination statutes, the state constitution, the common law, rather than for administrative review of the denial of his accommodation, he was not required to bring claims in Article 78 proceeding. That's respondents' own words. They acknowledge the lower court was wrong on the statute of limitations. They acknowledge that the lower court was wrong on the collateral estoppel. Because
even if we're not talking about the statute of limitations, those particular issues, how the only support that your client had other than his own, I don't want to say feelings, but his position on his religious beliefs was a letter from a pastor from Florida? Is that correct?
Your Honor, that was in the Article 78. And that was when it was denied. And that's when the lower court in the Article 78 said, look, I'm going to give the deferential standard to the city of New York. I want to move forward to this complaint. Because if we look at this complaint under this 3211 motion, my client is entitled to the inference of everything he's alleging being held as true. Under New York City human rights law, this court, the lower court...
Let me ask you this question, because I think one of the allegations is that, plaintiff said he was being created in God's image, right? My question is, are there any allegations that relate to how his religious beliefs conflict with the mandate?
So, again, that would be a question on the determination for an Article 78. This is a discrimination case, but he does...
He's saying that he wasn't afforded a reasonable accommodation. Is that your position?
That's one of the claims. That's correct. But let's be very clear. He's a 7-day Adventist. He says his body is...
He said that he's forbidden to take the vaccine. That's part of his position?
That's correct.
And how did he plead that he was forbidden, other than just saying, I'm forbidden?
Because he said, my body is a temple of God.
Okay, so I want to go back. I just, how did the complaint indicate, whatever the beliefs are, that is in conflict with the mandate?
So when we go back to the mandate, this complaint doesn't challenge the mandate. This complaint is challenging the NYPD's treatment of this 7-day Adventist. This Seventh-day Adventist was fully aware that many people were getting reasonable accommodations based on their religious beliefs. His belief as a Seventh-day Adventist that his body is a temple of God should have been enough to grant him the same reasonable accommodation that other people were granted. And at this 3211 stage, Your Honor, he should be entitled to the benefit. Let's have discovery. The lower court here applied the 3212 standard. The lower court here, sua sponte, went into theological arguments, just as this court's doing. None of us here are theologians. This is a New York State constitutional right. He's entitled to worship his God as he sees fit. He was entitled to have his job without any discrimination. That's not what happened here. This is a 3211 motion. Just let us go through discovery.
Well, let me ask you another question, because I don't have to tell you, because you've been here many times, and you already know the law. I mean, this court has upheld the procedures that's being challenged time and time again. So why now should we disregard that?
That's an excellent point, Your Honor, because there's two different ways this case can proceed. This case can proceed as Marstella, or this case can proceed as Hosking. Marstella was an Article 78 under contrived emergency situation. I'm asking at this 3211 stage, let's proceed as Hosking. Let there be discovery. Let the depositions come
In
out.
order to get there, counsel, there has to be more than a conclusory allegation. And I think that might be what's lacking. Or maybe you can point to me in the record or in the complaint where it's more than just a conclusory allegation.
On record page.
You know what? You can do that on rebuttal. Thank you.
Good afternoon, Tahir Sadria on behalf of the City of New York. The city is asking that the court affirm the lower court. Initially, collateral estoppel bars plaintiff's primary claims of failure to accommodate and failure to engage in a cooperative dialogue. Plaintiff brought these same claims in his prior Article 78 proceeding that was challenging the exact same denial of his request for religious accommodation that is at issue here. And Supreme Court denied that petition and dismissed the proceeding, implicitly rejecting those claims. And this precludes plaintiff from bringing the same claims again here. And in any event, his claims are further barred by stare decisis. These are not new issues that plaintiff is raising here. Multiple courts have heard and rejected the claims based on
Have courts heard it in the context of the distinction that your colleague here is making, the plenary action versus the Article 78? Have courts reviewed that?
They have. I mean, this court in Goolsby also found that the procedures in place for evaluating a request for an exemption from the employee vaccine requirement, that they satisfy the city human rights law cooperative dialogue. And the issue in both the Article 78 proceeding and in the plenary action, it's the same issue as whether or not it complies with law. And regardless of the proceeding, that the format of the action or the proceeding, the issue is the same. And in the second department, the court has found that allegations almost exactly the same as these fail to make out a claim for failure to accommodate, and also fail to make out a claim for failure to engage in a cooperative dialogue, and virtually all of the other claims that plaintiff is making here as well. And both of those, that was in FARA and in Currid, and both of those were plenary proceedings as well. I think the only other issue that I would say here is, again, as this court noted, the issue here is not the sincerity of plaintiff's beliefs. The issue is whether or not he has actually articulated a religious belief that conflicts with the vaccine requirement, and multiple courts have found that this bare bones allegation that he makes here does not satisfy that requirement. If the court has no further questions.
Any questions?
The city will rest on its brief.
Thank you.
The record, page 47, paragraph 19. As a devout seven-day Adventist and pursuant to the tenets of his faith, plaintiff explains he is created in God's image. The low burden for New York City human rights for a 3211 motion. That should be all that is required. But even if this court was to say, you know what, we're holding you to a higher standard under New York City human rights, New York State human rights, my client, as alleged in the complaint, still is entitled to the free exercise of his religion. He's still
That may be
entitled.
true, counsel, but how do you allege that that his religious beliefs are in conflict with the mandate?
His actions speak to the conflict.
I'm not asking about the actions. I'm asking how did you plead it?
We said he was terminated from work. He refused to get vaccinated. So he says,
You're answering your own question instead of mine. I'm asking you to connect it. I'm asking you, how is it that his religious beliefs are somehow impinged or offended by the mandate? How did you allege that?
so he said his body is God's temple.
What's the
To me,
follow-up to
that's
that?
there is no follow-up. He doesn't need a follow-up. It's the same when some religions.
So we're supposed to interpret from that his body is his temple, that he can't, no vaccine, you can't touch him. What are we supposed to do from that?
You're not supposed to.
allege it.
That's right, Your Honor. You're not supposed to interpret his theological beliefs.
It's not interpreting, it's
it
you
is
alleging.
interpreting.
Counsel, don't talk over me. That's going to be a problem for you. You're supposed to
Also,
allege it.
lower your tone, lower it.
My tone, I apologize. I think as a Christian, as a Seventh-day Adventist, I get very upset when we listen.
It's not about religion. We're
It is about-
we're not talking about the religion. We're talking about how did you allege that whatever his religious beliefs, which he is absolutely entitled to have, how they come in conflict with the mandate.
He said his body is a temple of God. The same
How
way.
does that, but there's no allegation as to how the vaccine would in any way violate that religious belief. You need to make a connection, which you don't do in your complaint.
So let's take away that out. What about the breach of contract portion? How do I get a 4-month statute of limitations on breach of contract?
So you're choosing not to answer my
No,
question?
I am answering, but I did
Counsel,
answer
we
it.
have the arguments. Thank you.
Thank you.
Matter of Manhattan Organization.
May it please the court, good afternoon. James Demetrio on behalf of the Appellant Manhattan Organization. And having listened to everything before, I appreciate the court's knowledge of everything that has been submitted and being up to speed on everything that's there. So I'm going to begin with I'm going to just cut right to the chase.
So let's do it.
The question, as I see it, is we're all aware of a city agency's discretion, how much discretion is, but under the irrational and arbitrary and capricious definitions, how much discretion becomes too much discretion.
Okay, let's cut to the chase, really, because the bottom line is that your client had a duty to update the information in the application if it changed before, respondent rendered its final determination. And we know about, the indictments. Was that done?
As to the indictments, no, it was not, and I will concede that all day long. He did say, he did do
Then
that right
what's
from
the
beginning.
problem?
Well, the problem is that the timeline is what we have as
The timeline, he submitted his application when, in 2020?
October 2020.
And then the first indictment was 1 year later, in July of 21?
First
And
indictment was July 2021.
right, and then we know what happened with that one. It was,
This court voided it.
yes, and then the second indictment in 2023.
Right.
And how long is the inquiry period?
The inquiry period goes 3 years before the application and up until the time HPD makes a determination. However, this is where my argument comes into play with respect to the timelines and how it becomes arbitrary and capricious. The timelines of the application for CONH say that HPD takes the application in. As it takes the application and it conducts an internal investigation. That internal investigation was completed in May of 2021.
There's no requirement that it then issue the order in a particular time frame, correct?
That's correct, absolutely. I'm sorry to interrupt, but I'm continuing.
I
the
prefer
time.
that you're not
Don't interrupt.
I apologize.
Don't.
Okay. So after the investigation is completed in May of 2021, city then sends out all of their notices as required by 2093D of the Administrative Code. That's the only time frame that is in place is the responses to those requests that the city sends out. That's a 30-day deadline for the responses to the city's requests to other agencies. So the city sends out its requests June 17th, 2021. By July 17, 2021, everything is complete. It is now ready for the city to make a determination, issue a
By
CON.
July 17, 2021?
Yes, Your Honor.
The first indictment was July 8th, 2021?
July 21.
So presumably within that time frame.
Just a few days after completion of the total investigation period. The time frame for the city to complete its investigation ended around July 17, 2021. First indictment was 4 days later, July 21.
I thought it was July 8th of 2021.
That's not, my record shows it July 21. Notwithstanding that, Your Honor, Mr. McCartney's comment to me, unfortunately, I only got this for purposes of appeal. I did not get it. I was
Stick
not.
to what's in the record, counsel.
Yes. Oh, well, okay.
So what he told you that's not in the record is not of interest to us.
I appreciate that. So he did not file an update to show the indictment. Our position
And why
is,
isn't that significant?
oh, I didn't say it's not significant, Your Honor. I did not. But what I'm saying instead is HPD had all of the time, finished all of its investigation before the first indictment came out. The first indictment was then voided right from the get-go in November of 2022. Between November of 2022 and July 31 of 2023, when the second indictment was issued, the city had all the time in the world to issue a decision on the merits of the argument.
Administrative delay doesn't defeat the agency unless there's a showing of willfulness or negligence.
I understand that, Your Honor, but the administrative delay is what is the key to this, because everything was completed in 2021. So if everything is completed, they basically sat on their hands for 3 years to come back and then say, you didn't tell us that you were indicted, therefore we're going to reject your application. They never denied the application.
So
by
you
the way.
can follow up on that on
Absolutely, Your
rebuttal.
Honor.
Thank
Thank
you
you.
so much.
Good afternoon, Your Honors. May it please the court, Diana Lawless on behalf of HPD. So,
Counsel, could you address the role of administrative delay and our assessment of the validity of the decision in this case?
sure. So first of all, it wasn't pleaded in the Article 78 petitions. We did not have any allegations that this delay in and of itself or any of the arguments he made by statutory timeframes, which I can come back to, do not exist in this framework. That was in the petition. If you look at 11 to 20, he just said that he must concede this, that the scope of the inquiry period should have not extended beyond the date he filed the application, and that the later criminal cases weren't relevant. That's obviously wrong, because he just admitted that the inquiry period goes until the day that HPD makes the final determination. So there was no basis for HPD when it answered, when it provided the letter and it provided the information that it had to defend on this, what he says about how long it took. HPD wasn't put to the proof of why it took so long. So there's no record that was developed on that was unpreserved. That's the type of thing that has to be alleged in Article 78 proceeding, and even if it's a due process claim, it can't be raised in the interest of justice here. But there's no, my adversary is wrong. The timeline never ended. There was no timeline here. That he goes through some statutory argument to try to say things had to happen by a certain date. There's nothing in the statutes, as we laid out in our brief, that says that. All that happened here, right, as he now concedes, under the rule, the HPD reviews the conduct during the inquiry period. The application, if it changes any time before HPD's final determination, the applicant shall promptly update it and submit it to HPD. the only dates that we know of is that we also don't know at what date anything was complete. We just know that HPD accepted the application on May 14, 2021, after it was filed in October 2020. The record was not made to address due process claims, but the inference can be made that this was during the height of COVID. What happened is he was told that he had to make these updates. They happened, and then at any time, the HPD regulation says if HPD determines at any time that an application contains a material misstatement of fact, HPD may reject and bar the submission of the new application for a period to not exceed 3 years. That's exactly what happened.
And counsel, I just had to go back and look at the record in terms of the date that the indictment came out. It was July 8th of 2021 because there was a press announcement from the agency.
Right, I'm not quite sure of the exact date, but right, if he's saying that he still had the obligation either way to say it, I mean, HPD's the entire time, we're saying HPD's, the application was open, so at any time he had to promptly update HPD, and he never did. And to the extent that he says that the HPD's investigation was ended in July 2021, there's nothing in the record that says that. I'm not sure what was happened, like where he gets that from. I think he thinks that there was a date that 30 days after somebody was supposed to do something. I know that all I can find in the record is that there was an inspection report at 155 that was in September of 2021, but there's no final determination that was made by HPD. HPD was obviously conducting an investigation. We see that from the papers that we put into the record.
Is there anything that requires HPD to give a determination within a certain time frame?
No, not in the statute at all. And as Your Honor pointed out, in order for a delay by itself, if a due process claim was preserved, there has to be a showing of willfulness or the result of negligence. All here that my adversary offers is rampant speculation and unfounded allegations of conspiracy about why HPD held on to this. But from our perspective, this was a clear-cut application of HPD's rules.
The bottom line here is that petitioner failed to disclose the 2 indictments during the pendency of the application, and certainly HPD, according to the rules, has the authority to reject the application where it contains a material misrepresentation of facts.
Correct, and HPD had to find this out from its investigation.
He said no. He said no and didn't initially.
He said no, and
didn't update it.
Right, he didn't update it, but then HPD was investigating. HPD wasn't doing nothing. HPD found this out, and HPD rejected the application and was allowed to do so under its rules. It's clear cut for us. All right, thank you, Your Honors.
So counsel, I just want to go back because I really had to go back and look at the record. And from what I can understand, on July 8th, the first indictment came down. And then on July 27th, an HPD investigator scheduled an inspection, so it was ongoing. So even at that time when the HPD inspector went out to the property, which was access was given on July 27th, your client was aware of the first indictment, and he still did not disclose it. I mean, that is right?
That's correct.
Okay, and so then that would be in violation of the application process. I mean, why do we even need to go any further than that?
Because the question.
Why is the 30-day even an issue at that point? Because why would they didn't make their decision within 30 days, even if that could be an issue, which it's not, but why would it be an issue when your client didn't do the first disclosure?
Very succinctly, Your Honor, that was 2021. HPD didn't issue a rejection until February 2024. What were they doing for?
Why couldn't they still issue it on the basis that in 2021, he did not disclose what there was to be disclosed?
The question here, Your Honor, is when an application is rejected or denied, you have to wait 3 more years in order to reapply, okay? So they sat on it.
Do you disagree with the analysis that administrative delay only comes into play if it's willful?
No, I'm taking a position, Your Honor. I would, unfortunately, it's not in the record, but I would like to know, when did HPD find out about the
So we're not going there since it's not in the record, so we're not
we do
going
know
there.
it's not from your client.
We know that it's not from my client, Your Honor, but they sat on the whole record.
And so did your client.
For years.
And so did your client, the one who had the obligation to disclose it.
He sat on, well, he may not have understood that he had the obligation to disclose that. He thought it was related.
You're not claiming that that relieves him of the obligation.
Right, well, the application was relating to harassment of tenants, and whatever the mindset would be, that's another story. But the bottom line is, HPD sat around for 3 years.
Thank you.
We're doing
Thank you both. Thank you.
Thank you.
Vasily?
May it please the court, my name is Merilda Petrinina, and I represent the appellant.
Can you speak into the mic, please?
I'm sorry.
No, you're fine. Okay.
My name is Merilda Petrinina, and I represent the appellant, Valentina Vasilyev. This appeal is about whether the trial court can dismiss a matrimonial action which has been heavily litigated for 2 years without applying the factors listed under DRL 76F.
No, I think the question is not as you would phrase it, but whether or not the trial court abused its discretion in deciding the motion for change of venue as it did, which is a very different question. Whether or not I would have done the same thing as a trial judge is not the question that we have to consider. The question is what the trial court here did was an abuse of discretion. So I'd really like you to focus on that question, because if it's not an abuse of discretion, we can't do anything about it.
Understood, Your Honor. So, viewed on that prism, indeed the trial court abused its discretion in dismissing the matrimonial action. The trial court treated relocation of the parties as disposition. Indeed, jurisdiction does not follow relocation of the parties. Jurisdiction does not follow zip code. What jurisdiction follows is judicial work. And
Wait,
in this
at the
case-
time that 6 months after they moved, at the time that the divorce action was filed, the children lived in New York.
Correct.
And the court certainly had jurisdiction over the custodial issues. Then the parties moved to New Jersey, and to my amazement, they didn't at that time discuss with their lawyers how that would affect the divorce proceeding, but apparently they didn't. And 6 months after that, New Jersey had jurisdiction over custody as well. So both states at that point had jurisdiction over custodial issues. So it seems to me that's a factor you have to take into account as well.
Yes, Your Honor, but after 6 months, no action was commenced in New Jersey.
But eventually it was.
All the record for this case is established here in New York State.
But now the children go to school in New Jersey.
That's correct, Your Honor. However, the history
And
of this case...
apart from one medical provider, all of the medical providers for the children are in New Jersey as well, correct?
That's correct, Your Honor. However, the fact that the medical providers or the teachers are in New Jersey, it's not the factor why this court should have based its decision to transfer jurisdiction in New Jersey. DRL 76F lists all the factors that the court has to consider before transferring jurisdiction. Jurisdiction has to follow judicial work, and the judicial work in this case is done here in New York for the past 2 years. Orders of protections are issued here.
Orders of protection can be enforced in New Jersey. New York orders of protection, New York orders of support can all be enforced in New Jersey. It's not a very, I mean, it's, we do have full faith and credit by one state to the orders of another state. So I don't understand what the problem is with enforcing those orders in New Jersey.
No, it's not about enforcing the orders. It's about where the history of this case is. If tomorrow we'll decide, the court will decide about what's the best interest of these two children, which is the heart of every custody and child support order, the best interest of these children will be found by reviewing the record that is in New York State. Because
what records are in New York State that
here
New Jersey court couldn't look at?
Here is the history of domestic violence, Your Honor. Here it was.
And why couldn't that be introduced in a New Jersey court?
Your Honor, by dismissing the case, the court failed to consider the best interest of these children. Dismissing the case wiped out the child support orders, wiped out all the support arrears. These children does not have any more an attorney to represent them. So
But
everything,
an attorney or other guardian can be appointed in New Jersey, correct?
that's correct, Your Honor. However, the best interest of these children and their well-being was protected only by the orders protections, only by the child support
Is it your
orders.
position that now that if the case goes to New Jersey, the arrears no longer exist?
Yes, that's correct, because the court did not make any findings regarding what about the enforcement of the existing orders. That's why in our argument, we say that the court should have gone through all the factors of the DRL 76F before deciding to dismiss jurisdiction. Relocation is just a factor. It's not a test. It's not the solution to transfer jurisdiction. Same with the home state. Home state just opens the door, triggers jurisdiction, but does not define that someone can walk through the door and assign jurisdiction in another court. So what I'm saying here is that this case is not about where these children will be tomorrow. This case is about whether a litigant will be allowed to escape the orders of one court just for his convenience. Everything is happening because the respondent thinks that he will get a federal decision in New Jersey based on his child support obligations.
Thank you, counsel. Thank you.
May it please the court, good afternoon. My name is Dimitri Masonette. I represent defendant, respondent.
There was an order in August of 2024 from Justice Chesler that ordered child support and attorney's fees.
Yes.
How can that order be enforced in New Jersey?
I would submit that based upon the order of dismissal that we argue was properly applied by the trial court and properly decided by the trial court, that once there's an order of dismissal that's based on forum nonconvenience grounds, as it was here, those orders would in fact be vacated. I would submit, however, that there's nothing in the record, as was argued in our respondent's brief, that of any claim on the record or even in appellant's brief that the defendant respondent failed to make any court-ordered payment obligations as it pertains to child support and even counsel fees. These obligations were actually paid in full, and as far as arrears goes, the argument on arrears, these orders were interim orders subject to reallocation after a trial.
So, but can plaintiff make, if plaintiff moves for child support in New Jersey, can those child support orders be made retroactive to the date of the original divorce action or only as to the second divorce action?
My understanding is because there's a subsequent filing that was made in New Jersey, right? Any kind of issue as far as retroactivity to a dismissed case in New York would not apply in the New Jersey case.
Does that achieve what we're trying to achieve here? I mean, if he hasn't paid his child support, if there are arrears, that the case gets sent to New Jersey and those arrears are now, according to what you're saying, and they're just gone. What about that?
Yeah, I would say if arrears existed, that would be the case. But there's no allegations and nothing on the record stating that arrears existed at this point. Moreover, in the fact, like I was saying, with interim orders, arrears, there was no actual determination in the trial court as to any arrears calculation because of the fact that if the case were to continue, it may be that there are no arrears that are owed. It may be that there are some arrears that
Now,
are
if
owed.
arrears are owed, they're gone.
I'm sorry?
But now, if arrears, let's assume that they are owed, or they were owed.
Well,
that's it.
If they are owed, that would be it, but that would be where they would have to apply in New Jersey for the New Jersey child support, and that is a different law in the state that they are residents in, where it's undisputed that all the parties and the children are residents.
And did Ms. Vasilev, I'm sorry, did Ms. Vasilev make the argument in the motion court that dismissing the New York action would deprive her of the ability to go after arrears in child support? I didn't see anywhere in the record where she made that argument. Where is it? Is there such an argument?
I don't have a recollection of that. I do have a recollection that there were not necessarily in the motion papers before the trial court, but in the brief that's before this court, there is some kind of argument as to that. That was
I like
point
to
two.
go back to the party's connection to New Jersey as opposed to New York. Now, I believe that the children, the parents, they lived in New Jersey for nearly 2 years, correct?
Yes.
And, you know, I think while one of the children had a doctor in New York, most of the caregivers were in Jersey. Talking about the nannies, the physical therapists, the teachers, the social workers. So most of the caregivers were now in New Jersey.
Not only are they now there, but it was at least 23, and that's in the motion papers and also in my respondent's brief, I believe page 17 of that, where there was specifically at least 23 different providers for the children, all located in New Jersey. Now, the one provider that's claimed that was a New York provider, medical provider, that provider was not, for instance, the children's regular pediatrician. That was for some kind of, it was a psychosocial evaluation that was done unilaterally decided by the plaintiff appellant to have one of the children evaluated, and that's what the provider is that they're asserting is a provider for one of the two children in New York. That's not the case. That was just an evaluation, and everyone else is in New Jersey, not just the parties and the children, but all of their providers are in there. Thank you.
Thank you.
Thank you, Your Honors. So I'd like to address with regard.
Counsel, can you address whether in the motion court you raised the issue of arrears, that your client would be deprived of arrears in child support if the case were transferred to New Jersey? I looked at the record and I didn't see anywhere where you made that allegation in the motion court. Could you point me to that?
I don't have a recollection right now, Your Honors. I know very well it was presented in our brief. It was made this argument.
I understand that, but I'm talking about in the motion before the trial court. If it was not made in the motion before the trial court, we can't really consider it here. I was hoping you could point me to that.
I do not have a recollection right now, Your Honors. However, what the judge did in the order, the judge cited DRL 76F, and in order for the judge to dismiss the case based on the requirements of DRL 76F, she should have made an argument and a finding about the best interest of these children. Counsel argued about the child support arrears and child support order. Respondent started paying child support only in August of 2024. This action commenced in March of 2023. For more than a year and a half, it was the appellant the only one who responded to all the children expenses. She wiped out her retirement accounts to respond and to meet the children needs. So it's not fair to the appellant, it's not fair to the children. Everything to be wiped out after 2 years of heavy litigation. Jurisdiction does not follow zip code. Jurisdiction has to follow judicial work, has to follow the best interest of these children, has to follow the best interest of the parties.
The attorney for the children present at the court below for the relocation? For the dismissal of the...
Yes, Your Honor.
I don't see any records by the attorney for the child.
I know that she has submitted a brief for the appellate division. I think she made her position, I'm sorry, Your Honor.
For the family court.
For the Supreme Court, you mean?
Judge Chesler.
I mean, she presented an oral argument in the record, if I have a clear recollection, saying that she opposes any dismissal of the case.
Thank you very much. Thank you both. Palazzo v. Calvert Lancaster Housing.
Good afternoon, Your Honors. May it please the court. Maria Masucci for appellants. There's basically two established and undisputed facts here. One is the plaintiff alleges she's tripped and fell on the sidewalk. The location of that accident is undisputed. It occurred adjacent to the property at 172 East 122nd Street. Equally undisputed is that my clients, the appellants, do not own that property. They own the neighboring properties at
Your-
180.
Your motion, there were photographs submitted,
Correct.
right? And the photographs show a lot and then a building next to it, 180.
Right.
How are we supposed to know where that lot belongs?
Well, the deeds and the tax maps that are on ACRIS and the New York portal show that they're separate lots, that fenced-in area. In fact, Mr. Walters, who was the executive director, attested that the 180 is on, if you're facing it, on the left side, and 164 is on the right side of that fenced-in area. That fenced-in area is comprised of 172 and 170 East 122nd Street.
Yeah, Walter Roberts, I know that was the gentleman who submitted the affidavit, but I was just curious because, you know, he says it's not our property, but it was silent about the basis of his knowledge. I mean, did he review the deed? Did he review a land survey? Because it doesn't say anything about that.
No, he doesn't. But it's based upon his 14 years as the executive director.
But you mentioned that the deed and the act research, who's supposed to do that? The court?
I'm sorry?
The deed?
Well, it is requested that the court take judicial notice of the government website. It's ACRIS.
Were printouts or something of that nature attached to your motion?
To the motion, no.
We're supposed to go and search for it ourselves?
No, I'm not asking you to search for it. I did provide.
I just want to go back because, you know, all we have is the affidavit of Mr. Roberts and pretty much, you know, the photos, we know that.
Right.
But he just says it's not our property. And so the court below was just supposed to take him at his word when there's no documentation. We don't know the basis of his knowledge.
Well, there are the court cases where property is established who the owner is by testimony. There's no survey. There's no, people will come in and testify. You know, I'm from Calvert Lancaster Funding Development. We own 180.
I mean, but counsel, if you submit a photograph of a parking lot and 180 next to it, why wouldn't we assume that parking, I don't know, how can we just assume that parking lot either belongs or doesn't belong to 180? How do we know that there's a building on the other side? How do we know that there is, what the address for that vacant lot, that parking lot is?
Well, one, the co-defendants in the action. I mean, it's alleged in the complaints about the ownership of the properties. There's two properties.
This is your motion for summary judgment. I'm talking based upon your motion for
Right.
summary judgment. How can we make that determination?
Well, Mr. Walters attests that, you know, the fenced-in area, he looks at the photograph, he says this fenced-in area, based upon my 14 years of being the executive director for Hope Community, who is the managing agent for 180 and 164, this fenced-in area is not part of our properties. Does he know who they belong to? No, he can't attest to that, and that's where ACRIS and you know, the portal come in for the tax maps, which
But those weren't attached to your motion.
I understand. I believe that the affidavit was sufficient, but in addition, there is some case law in my papers that the court can take judicial notice, and I didn't want to just sneak them into the record. I put the links, which are properly before the court, I believe.
I think we can do the research for you.
So you know what, we'll address these things on rebuttal. We'll now hear from the respondent. Thank you.
Thank you, Your Honors. And may it please the court, Ryan Goldstein for the plaintiff respondent. So a few things. First is the buildings on either side of the lot are actually owned by the defendant appellant. So that complicates it even further because now we don't know if that lot belongs to one side, other, or both. We also don't know if they've ever made special use of it. The Roberts affidavit does not speak to whether there was any special use of that particular lot.
Whether they created the condition.
Sorry?
Whether they created.
Or whether they created the condition by that use. In addition, the appellant realized the errors of their way in the filing of this motion, and they recognized that the lower court properly denied the motion based on the very points that we've all spoken already, which is why they made a motion to re-argue and then attached the tax maps and deeds to the re-argument motion. But when they did that, they did not amend, supplement, or correct in any way the Roberts affidavit. So the Roberts affidavit was used in its original form, not mentioning whether he reviewed anything, not mentioning the basis for his knowledge, and frankly, that results in the entirety of that affidavit being conclusory and having really no value. And my colleague mentioned that Mr. Roberts didn't know or wouldn't know who owns the lot. No, if he's in a position to say they don't own the lot, tell us the basis for that knowledge. And based on those documents, I believe he should be able to tell us who owns that lot, who uses that lot, who makes any special use of that lot. Frankly, Your Honors, they failed to present their evidence, and the lower court properly dismissed, I should say, denied their motion, and ultimately, this court should uphold that decision.
Thank you very much. Thank you. And I realize you didn't ask for rebuttal.
No, I didn't.
Okay.
If the court has any further questions, otherwise I'll rest on.
I think we have it. Thank you so much. Thank you both. All right. Bowman versus Cosby. You may begin. Thank you.
Good afternoon, Your Honors. My name is Kimberly Klein with Moses and Singer. We represent the Carsey Warner Company. The Court of Appeals in More Charitable, a decision that came down in June of 2023, gives us the roadmap as to what a plaintiff has to show in order to make out the notice and knowledge element of a negligent hiring claim. And when I say negligent hiring, I mean negligent hiring, supervision, and retention. The Moore Court tells us that the plaintiff has to plead actual facts to show that my client, Carsey Warner, had notice or knowledge that Mr. Cosby drugged and raped an individual prior to plaintiff's injuries. And that's what she does not plead anywhere in her complaint. So for instance, let's look at the complaint. There are 4 types of allegations. One of those allegations is that Carsey Warner should have known that Mr. Cosby was drugging and raping women in the 1980s. The lower court, when it denied our motion on this claim, said that it was sufficient for a plaintiff to allege that the employer should have known about this wrongful conduct. The lower court cites to 3 First Department cases. 2 of them are from February 2025. 1 is from 2024. The Court of Appeals came out with a decision, however, in this year, in April of 2025, making very clear that it is insufficient to simply allege that an employer should have known of the wrongful conduct to show the notice or knowledge claim. This is Nellenbach v. Madison County, and the Nellenbach court makes clear, quote, "We have never held that a party can prove negligent supervision by stating the employer should have known an employee was likely to engage in dangerous conduct." And the Court of Appeals cites to More Charitable, which again made very clear that the plaintiff has to plead actual facts showing my client knew that Mr. Cosby was acting outside the scope of his employment and engaging in criminal conduct. That is what's missing from this complaint, and based on this alone, the lower court's decision should be reversed. Now, I do want to say one thing about the 3 First Department cases that were cited. When you look at the underlying complaints, which are critical to this analysis, these decisions, like Fields and Pertardi, do have allegations of prior notice or knowledge of similar conduct because victims came forward in those cases and reported the abuse, and those employers or institutions simply turned the other cheek. And that's what More Charitable tells us you cannot do. You cannot know of the wrongful conduct and turn the other cheek. Here, conversely, there are no facts alleged that my client knew that Mr. Cosby was engaging in this conduct prior to plaintiff's injuries. Another type of allegation that the plaintiff likes to make are these sweeping generalities like Mr. Cosby drugging and raping women was open and notorious. There is not one fact to support this, because at the time, nobody knew about Mr. Cosby's behavior. This was known this century. Now, if this conduct was open and notorious, then the plaintiff could have pled one fact showing that Carsey Warner or anyone working for Carsey Warner should have known that Mr. Cosby was hurting women and did nothing about it. But the plaintiff does not plead that. As another example, the plaintiff alleges that Carsey Warner employees knew Mr. Cosby was drugging and raping women during this period and ratified and covered up this conduct. She does not identify one single employee who knew about the wrongful behavior and covered it up. These are speculative, conclusory allegations, and they are insufficient to make out a claim for negligent hiring because they do not show prior notice or knowledge of the type of conduct that has to be alleged here. And so since my time is limited a little, I just want to go to the facts quickly of Moore.
And I have a question, but I'm going to give you more time because I want to know, was there any nexus alleged between, with respect to your client's actions or inactions and the harm, caused by Mr. Cosby?
Okay, great. So the should I go to just the facts of Moore real fast?
No, my question and then the facts.
Okay. So at one point, the plaintiff, and I just want to make this point first before I answer this, because it's linked. In 1985, the plaintiff says she was introduced to Mr. Cosby through her talent agent in Colorado. The two of them then proceed to have a 3-year relationship between 1985 and 1987, where they fly all over the country, where the plaintiff thinks that Mr. Cosby is going to launch her career, introduce her to people in the industry, and mentor her. My client is a production company. They are not a modeling or talent agency. They do not find unknown wannabe actresses and fly them over all around the country and mentor them. My client produced The Cosby Show in New York City between 1984 and 1992, right? There is no connection between this relationship and plaintiff's injuries. So to your question, the plaintiff says at some point in 1986, her agent moves her to New York City and rents her an apartment so she can continue this long-term relationship with Mr. Cosby. So what happens in New York City? Well, we know what doesn't happen. At no time does this plaintiff go to the premises of Carsey Warner. She never visits the studio. She never auditions for a role on The Cosby Show. She doesn't appear on the episode of The Cosby Show. She doesn't meet anyone from Carsey Warner. She doesn't meet anyone from The Cosby Show other than Mr. Cosby. She does not report any wrongful conduct by Cosby to Carsey Warner. So what does the plaintiff say? She says on one occasion in 1986, Mr. Cosby offers to get her an audition for an episode of The Cosby Show, right, for a role on The Cosby Show. And she goes to Mr. Cosby's home, and there she says he drugs and rapes her. Now, even if we presume is true, which we must on a motion to dismiss, that my client knew that Mr. Cosby could get an unknown wannabe actress and audition for a role on The Cosby Show, the Court of Appeals tells us in More Charitable that is insufficient to show prior notice or knowledge. So what does More Charitable say? the plaintiff, who was a foundation and more charitable, says you, employer, should have known that your employee would steal money from us. It was an embezzlement issue. And because the employee had a drinking and a gambling problem, the Court of Appeal said that is insufficient to show prior notice or knowledge of similar conduct because those vices are not the same vices as knowing someone will steal money, embezzlement. It has to be the same conduct of the injury-causing conduct at issue. That is applicable here as well. Just because my client, if we presume true, knew that Mr. Cosby could get this plaintiff an audition for a role on The Cosby Show does not mean that my client knew that Mr. Cosby was drugging and raping women or hurt this plaintiff in any way. Does that answer your question?
Thank you. We'll now hear from the respondent. Thank you.
Thank you.
May it please the court, Annette Hasapidas for plaintiff respondent in this case. If we were at the summary judgment stage, I'd probably be in a difficult position. But this is pre-discovery motion to dismiss. My client was 19 years old back in the 1980s. So addressing...
That causes us to have to focus on the complaint.
Yes.
And I've read the complaint several times, and I'm just troubled by, I don't see any clear allegation that any particular employee of Carsey Warner was facilitated or participated in or encouraged or covered up any actions by Mr. Cosby toward the plaintiff. And it seems to me that we don't, without any allegations like that, but just very general allegations, there's not enough there. So perhaps you can point me
Sure.
the best of your allegations.
Your Honor, I'd refer the court to pages 5 and 6 of Respondent's Brief where we block quote.
I'm talking
from-
about the complaint.
Yes, well, we block quote from the complaint, the paragraph cited there. So 144, 145, where the complaint alleges in very specific detail that the employees and agents of Carsey Warner were Mr. Cosby and the security guards. The security guards were the ones that were responsible for...
I didn't see any allegation that his security guards are employed by Carsey Warner. I looked for that because I thought that might be where you were going, but I didn't see anything that suggested that that was, I didn't see any allegation to that effect.
At paragraph 41 at page 65, at all relevant times, the employees, agents, and/or servants of all the defendants facilitated the assault of women by Cosby by, among other things, bestowing him with power or the appearance of power at the Cosby Show and beyond, despite his propensity, bestowing...
So that paragraph hasn't yet mentioned bodyguards, right?
Bestowing Cosby with the authority or the appearance authority, despite his propensity, permitting him to access women, providing women to Cosby to be sexually assaulted, providing Cosby with resources and staff to aid...
But so far you haven't said anything about any allegations that the bodyguards were employees of Carsey Warner, right?
Well, as I'm saying here, by providing Cosby with the resources and staff, bodyguards, to aid or cover up his sexual abuse of women, failing to protect the women, including actresses hired auditioning for or seeking roles, encouraging women to meet with him alone and without adequate supervision, covering up the sexual assault of the women. It was the security guards that assisted him after he assaulted
There's
women.
nothing in here that says the bodyguards are employed by Carsey Warner, is there?
It is the staff.
I didn't see nothing in what you just, I'm looking at paragraph 41.
Yes.
There's nothing there that says that the bodyguards are employed by Carsey Warner, and I didn't see anything to that effect anywhere else.
Your Honor, the only employees that are referred to in the factual specifics of the complaint are the security guards, so the
Right,
reference
but you
to...
never, excuse me, I didn't see anything in your complaint. I agree that there are specific allegations about the bodyguards having a role in Mr. Cosby's assaults on women.
Correct.
But I don't see any allegation that the bodyguards were employed by Carsey Warner. Where is that allegation?
It is the staff. It's the reference to the staff, and they are the defendants. I mean, you have to read the complaint with more liberally.
No, you need, okay.
Let me continue, Your Honor. Counsel, with respect to notice, we have a 19-year-old in the 1980s. It is well known in these cases that the defendants are typically in exclusive possession of the knowledge of the defendants, of Mr. Cosby's or the perpetrators' other conduct. Moore versus Charitable applies here. In Moore, the court said that allegations of actual knowledge of prior acts by an employee are sufficient to satisfy the notice element. In Martinez, the court said that you do not need to plead an evidentiary fact. You need to plead notice, which was pleaded here. I see your concern, Judge Gesmer, so I'm trying to locate. Here, Carsey, Your Honor, further, the paragraphs quoted at pages 25 to 26 of the brief, it's the reading of the complaint is that at all relevant times, Carsey Warner, their employees, agents, and/or servants facilitated and covered up Cosby's serial sexual abuse and rape of women. The reading to be given that included the security guards because they're the only ones who are referenced in connection with the sexual assaults. There's no other reference to any other staff by the defendants except the security guards. So, Your Honor, I see my time is up. So it is the only possible conclusion to reach here is that the reference to staff included the only employees who were referenced in the complaint, the security guards.
Thank you.
Thank you.
Okay, thank you, Your Honors. The security guards are referenced in connection with the plaintiff traveling to Atlantic City and having an incident with Mr. Cosby there. And the reason this is so important is, as I said, my client is a production company. After the plaintiff alleged that she was drugged and raped by Mr. Cosby in her home, in Mr. Cosby's home, what did she do? Did she go back to Colorado? She did not. She stayed in the New York area until the following year in 1987, when her agent called her and said, I'd like you to travel to Atlantic City and stay in a hotel where Mr. Cosby is performing. And she talks about security guards and incidents in Atlantic City. But this trip to Atlantic City had nothing to do, once again, with my client. My client doesn't know this woman exists, right? She never met my client. My client didn't send her to Atlantic City. This personal long-term relationship between the plaintiff and Mr. Cosby and maybe the agent has nothing to do with Carsey Warner. And let me address also this discovery issue. So the plaintiff says, well, the knowledge of what Carsey Warner knew about Mr. Cosby's criminal propensities is uniquely in Carsey Warner's notice or knowledge, right? And they say, therefore, we should be entitled to discovery to embark on a fishing expedition so we can try to figure out what Carsey Warner knew 40 years ago. But that is not the law in the state. The law in the state is more charitable. You have to first state a cause of action for negligent hiring, including prior notice or knowledge that my client, there are facts that show my client knew Mr. Cosby drugged and raped a woman prior to plaintiff's injuries before you go to discovery. And that's why the lower court's decision should be overturned and our motion should be granted. Thank you.
Thank you both.